Morning. My name is Betty Rankin Widgeon. I have been appointed by the Michigan Supreme Court to serve as the master in these proceedings. Today is November 24th, 2020. I'm going to start by asking counsel if you would please place your names on the record. Weingarten.
Good morning, Your Honor. My name is Laura Weingarten. I am one of two disciplinary co-counsels.
All right, thank you. Also co-counsel with you, Mr. Helland.
Good morning, Your Honor. Lynn Helland, Disciplinary Counsel.
Thank you. Mr. Campbell.
Your Honor, Donald Campbell, co-counsel for Judge Morrow.
Thank you. Jacobs.
Yes, good morning, Your Honor. Elizabeth Jacobs, co-counsel for Judge Morrow.
Thank you. Good morning, Judge Morrow.
Morning.
Thank you. At this time, I have decided that we are going to call one witness out of order, and that is before the disciplinary counsel rest. We're going to have Mr. Jeffrey Edison. That is my understanding. Is that correct, counsel?
Yes, Judge.
All right. And are you ready to proceed at this time with me swearing in Mr. Edison?
Yes.
Mr. Edison, I want you to please raise your right hand to be sworn in. I'm going to give you the usual oath, and then I'm going to tell you about the orders that are in place specifically for this particular hearing. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Thank you. You may put your hand down. What is your name?
Jeffrey Lee Edison.
And Mr. Edison, would you please spell your name, please?
Jeffrey Leedison.
Thank you. Mr. Edison, the other two items that I need you to certify or to swear or affirm to are these. The first one is the amended sequestration order. This has to do with witnesses, and it remains in effect until the witnesses are released from it by the master or until the proceedings from before the master conclude. So this order prohibits any witness, except while testifying during the proceedings, from discussing her or his testimony in any format or by any means with another witness. It also prohibits the witnesses from viewing the proceedings on any device, from listening to the proceedings on any device, and accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to the discovery of the failure or violation. The second is the amended order regarding hearing and witness protocol. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room where you're testifying, Mr. Edison?
I'm in a hotel, and my wife is in the other room.
All right.
But other than her, that's all that's present.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, such as laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Mr. Edison, do you understand those two orders?
Yes,
Do you swear or affirm that you have abided by these orders and that you will continue to abide by these orders?
yes.
All right, thank you. I think we're ready then to proceed, Ms. Jacobs. Go ahead.
Thank you, Judge. Mr. Edison, can you please tell us where you are right now?
In OSU, OSU, Ghana, West Africa.
And how long are you there for?
Approximately 4 weeks.
Are you a Detroiter?
Yes,
How long have you lived in Detroit?
since my birth in 1951.
Thank you. I'd like you to tell us a little bit about your background. Can you do that for us? You can start with schools and work up to your legal profession.
I'm a product of Detroit Public Schools, having graduated from Mumford High School in 1969. I went to Howard University in Washington, D.C., where I received my bachelor's degree in political science and history and education. I then returned to Detroit and completed my Juris Doctorate degree at Wayne State University Law School. Having completed that in December of 1975, I then was licensed to practice law in May 6, 1976, and have continuously practiced law since then.
Is your office, where is your office?
My office is located at 500 Griswold Street, Suite 2410, Detroit 48226.
Did you, are you familiar with, I'm going to call it Recorder's Court. What is Recorder's Court? Do you still call it that?
Many of us still are stuck with that reference because of the historic significance it has had for the city of Detroit, but Recorder's Court had jurisdiction over any and all felony criminal matters that occurred within the city of Detroit, and has since been abolished through legislation, and the jurisdiction was merged with the Wayne County Circuit Court.
Thank you. So you'll know that when I mention Recorder's Court, you know what we're talking about, correct?
Yes, yes.
What was your first job in the legal profession?
With the Defender's Office under the supervision of myself. So
Can you tell us the nature of your practice?
at that time, the Defender's Office and my practice concentrated on indigent representation of indigent offenders who were charged with felony violations. And so I began as a trial lawyer and have been a trial lawyer since.
As a trial lawyer for the Defender's Office, what court did you go to?
While working at the Defender's Office, solely and strictly the Recorder's Court.
How often would you go to court?
Every day.
How many cases might you have per day?
Oh, I don't know how many cases I might have had per day. I was at the Defenders between 1976 up until May of 1980. And during the course of that 4-year period, the Recorder's Court was experiencing an overload of cases in terms of management backlog. And so they had what was called a crash program. that was administered by an administrator appointed by the Supreme Court of Michigan, T. John Lisinski. And during that time, I don't know how many cases per day, but I know my first year of practice, I tried maybe 15 jury trials my first year, or close to that.
Besides the practice of law, are you involved in any organizations whose goal is to promote fairness in the law and in society?
I've been a member of the National Conference of Black Lawyers since October of 1974 as a law student, having a second-year law student, having attended National Conference of Black Lawyers annual conference in New Orleans, Louisiana, and having, or afterwards, returned to Detroit. And we organized, I was one of the student founders of the National Conference of Black Lawyers Michigan chapter in March of 1975. And I've been continuously involved with an active member of the National Conference of Black Lawyers. I've also participated with the NAACP Legal Redress Committee. And I've also was one of the founding one of the initial board of directors of the criminal advocacy program that was created by the Recorder's Court Judiciary, together with the Criminal Defense Bar in 1983. So that was involved in training lawyers to develop trial advocacy and trial skills, and I've been involved as not only on the board of directors for many years, but also was a lecturer in the criminal advocacy program. I've also lectured with the with CDAM, Criminal Defense Attorneys of Michigan, and that may be about it. With the National Conference of Black Lawyers, I was co-chair, a national co-chair, and of the of NCBL's criminal justice section.
Did you have any input into the Constitution in South Africa?
Yes, and prior to Nelson Mandela's release from prison in 1991, one of the leaders, or a person involved in the leadership of the African National Conference, Abdullah Omar, was traveling through the United States, trying to organize efforts in preparation for the not only the imminent release of Nelson Mandela, but also the African National Congress was anticipating a victory in the first free elections to take place in South Africa. And so Abdullah Omar was, for the ANC, was organizing what was later referred to as Constitution-making conferences, which was a series of conferences held in Johannesburg, South Africa, and wherein various issues, constitutional issues, were presented to the ANC to assist them in their process of developing different aspects of the Constitution. And so I, together with Shannara Gilbert, who was a professor at CUNY Law School in New York City, who had a background in criminal justice, she and I co-authored a paper on the right to counsel, constitutional right to counsel. And I made the presentation at the Constitution Making Conference in Johannesburg, South Africa
Thank you.
in 1991.
Thank you. Turning to Judge Morrow, can you tell us when you first met Judge Morrow or became aware of him?
Well, I've known Judge Morrow for over half a century. We met, I believe, I had to be at least be 15. I was either 15 or 16 years old. And we both were on the junior varsity basketball team. And that is my greatest recollection of how we met. We may have met outside of basketball, but certainly the playing junior varsity basketball was the significant memory at this point.
Was that for Mumford High School?
Yes, at Mumford High School, yes.
We have to get that in because there's going to be another Mumford basketball player who will testify. Can you tell me, did you follow Bruce Morrow's career? Can you tell us about that?
Well, being on the same basketball team, you know, I don't. He may not know this, but when we were on junior varsity, it was always expectation that you might be brought up to the varsity team, particularly during mid-season, because we were on semesters then. So it was a September class and it was a January class. And so this would have been in the January of '68, that when the season began, we both were on JV, and we both played forward.
Did there come a time that he went to college? Can you tell us about that?
I believe I went to Howard, and Bruce was perhaps a semester or so or a year behind me. I went to Howard, and I believe he went to Eastern Michigan, and at some point may have been a firefighter on the Detroit Fire Department. And then later, when I came back to Detroit, I learned that Bruce went to Howard University's law school. And so then after he graduated from Howard's law school, I don't know if it was immediately, but at some point he began or started at the defender's office, and I was at the defender's office at that time. So, you know, we just coming from Mumford and then Howard connection, you know, and then the defender's office.
Let's turn to your experience practicing before Judge Morrow. Have you had the opportunity to appear before him? He is a judge and you as an attorney?
Yes.
Would you spend time in the courtroom waiting for cases to be called?
Yes.
Did you have the opportunity to observe him and his interaction with attorneys?
Yes.
Were you able to observe his interaction with jurors?
Yes.
Were you able to observe his interaction with the general public?
Yes.
In regard to defense counsel and prosecutors, can you describe what you observed in terms of his conduct with them?
Well, I think that just overall, across the board, I think one of his objectives and goals, from my perception, was to demystify the courtroom process, to communicate with the potential jurors and the jurors in a way that they have an understanding of their responsibilities as triers of the fact, their responsibilities of, if you will, using their own experiences to evaluate and assess what is being presented, that the law was not some authoritarian, mystical concepts, but very practical and basic. I think he appreciated good advocacy and demanded preparedness when you came into his courtroom across the board of both defense counsel and prosecutors. I think he exemplified a degree of humility from the bench and was not someone who was, if you will, stuck on himself by virtue of being a lawyer, by being a judge and having a role. He wanted to allow and create an atmosphere where the prosecutor and the defense had the opportunity to present their respective positions and interests without imposing his own or injecting his own perhaps perceptions of the case. As long as counsel was complying with the dictates of the law in terms of decorum, in terms of presentation of evidence, in terms of oral advocacy, then he would sit back and let the prosecutor do what he or she was supposed to do and allow the defense, he or she, to advocate its position.
I'm concluding from that he treated both sides fairly. Is that correct?
Unquestionably.
Have you observed his interaction with female defense attorneys and female prosecutors?
Yes.
And can you tell me, was there any difference in how he treated women from men, male attorneys and female attorneys?
Oh, I think equally. I mean, he equally. He allowed each gender to, or each person, regardless of gender, to advocate their professional position.
Did he ever use sexually graphic language in an inappropriate manner, either from the bench or to attorneys?
Not that I'm aware of.
Is there anything in his interaction with counsel for both sides, male and female, that would erode public confidence in the judiciary?
Absolutely not. I think that his conduct certainly enhances confidence in the process and the integrity. I'm one to think that it's extremely important that the public is well informed of what is going on in the courtroom and the respective roles of all parties. And Judge Morrow was someone who I believe took that very seriously and represented to the public essentially that it is their court. It is the people's court, not the judge's court, not the defense or prosecutor's court, but the people's court, where they come in and listen, assess, and evaluate what is being presented. And then it is their jurisdiction, the jury, as trier of facts, to arrive at what they believe to be a true and just verdict.
Did you ever observe him to be discourteous or disrespectful to either jurors, attorneys, the general public?
No.
You're familiar with chambers conferences, is that correct?
Yes,
Had you ever, strike that. Is there a difference in how judges and attorneys act in chambers from how they act in court?
yeah, I think so, yes.
What is the difference?
Well, it's been my experience that chamber conferences, meetings, is informal. Certainly, as distinguished from in court on the record proceedings that are formal. And informal in chambers would be the difference. It's informal, it's not, it's still serious, but it's informal.
And have you had chambers conferences with Judge Morrow and a prosecutor from the other side, or a prosecutor?
Yes,
And strike the and. Was he discourteous or disrespectful in chambers?
I've never witnessed that.
Did you hear him use sexually graphic language in chambers that was inappropriate?
No,
Strike that. Have you ever seen him overtly eyeing women attorneys who appear in front of him?
no.
Okay. Do you want to explain? You have a strained expression on your face.
Well, I don't, that the reference to eyeing is, I suppose, well, not suppose, it is very subjective, and I certainly cannot speak to what someone else may feel in that context, but I've never observed that at all.
In your, would it be 44 years of practice?
Yes,
Okay. And when was, do you remember how long Judge Morrow has been a judge?
I know, that's a good question. At least 25, maybe going on 30.
And during, strike the and, during that time, how often would you say you've been in his court?
Well, you kind of look at the draw in terms of case assignments. Sometimes over a period of time, you may have the same judge 4 or 5 times and then not be before the judge in a matter of years, So I don't know how many times I've actually had cases, but in addition to having my own case before Judge Morrow, there have been many times that I've come in to just watch and observe what was going on in his courtroom.
I want to turn to your opinion and any reputation evidence you can offer about Judge Morrow. What is your opinion of Judge Morrow's reputation for integrity? Strike that. What is your opinion of Judge Morrow's integrity?
It's of the highest quality of integrity. I can't say how high, but it's of the highest quality of integrity.
Would you know his reputation for integrity? Do you talk to other attorneys about him?
Yeah.
In fact, attorneys spend a lot of time talking about the judges they appear in front of, correct?
That's correct.
And do you know his reputation among other attorneys for integrity?
Yes, he has the reputation of being, at least right now, probably one of the best or the best trial judge in the criminal division. And I say now because over the years, I would have said he was one of the best. But right now, in terms of what's on the bench, he is the best. And I think that that is shared by many in the defense bar.
Going back to his reputation for integrity, do you know what that is? What, does he have a reputation for integrity?
Highest degree of integrity.
What is Judge Morrow's reputation for how he conducts himself? That is he dignified? Is he proper?
Yes.
And is that also your opinion?
Oh, absolutely.
Does he have a reputation as a judge who swears, who uses sexually graphic language inappropriately?
No.
In your opinion, have you ever seen him swear in court or use, I think I already asked the sexually graphic question. Have you ever seen him swear?
I've never really seen him exhibit anger or frustration. Oftentimes there are disputes between trial counsel, both defense and from the prosecutor with the judge, where the exchange is intense. Or certainly it may, the tone may rise other than just the average degree of advocacy. And in those moments, Judge Morrow certainly will let you know that he is the judge and that he, runs his courtroom, but I've never seen him personally become angry or exhibit anger in the exchange with the lawyers.
Lastly, almost lastly, does he have a reputation for harassing women, especially female attorneys?
No.
And what is your opinion? Does he harass female attorneys or prosecutors?
I don't know him to harass either prosecutors or defense. He holds both sides to a high standard of professionalism. That's both sides.
And in your opinion, does the judge have a responsibility to try and improve the quality of legal practice by attorneys who appear before him?
I don't know if they're required, but for me, the judges who do try to enhance the quality of advocacy in the courtroom, and Judge Morrow is one of those, I think that it is an outstanding attribute of being a judge, that lawyers, each of us, all of us, have our first case, and we have our second, third, and fourth case. And I think trial advocacy is an art that you're just not endowed with being a great trial lawyer, but that it is something you acquire over time and experience. And Judge Morrow is one of several judges over the course of my years that who would in chambers or off the record would offer advice and critique of what was being presented. And so I think that he acknowledged great advocacy, and he wanted both sides, the prosecutor and the defense, to come to court well prepared and to advocate with great professionalism.
This is my last question, and it's an important question. Tell us what the weather is like in Ghana.
Hot, hot, hot.
Thank you, your witness.
Go ahead, Ms. Weingarten, when you're ready.
Good morning, Mr. Edison.
Good morning, Ms. Weingarten.
How are you today?
I'm fine, thank you.
Good. So you're here to testify today to several things. First, that Judge Morrow never used sexually graphic language in front of you, right?
I don't know if that's why I'm here. I'm just here to, to answer questions about Judge Morrow. Whatever questions I'm posed, I'm prepared to answer.
All right, so you're really here to be a character witness, right?
Yes,
And you've already testified about your opinion and Judge Morrow's reputation. Is that right?
yes,
So one of the things you said was that you've never heard Judge Morrow use sexually graphic language, right?
Objection inappropriately was the qualifier.
I don't know if that's how the question was phrased on direct exam.
At least once it was phrased that way.
Is there an objection?
I can, how about this? I'll just rephrase the question and I'll include what Ms. Jacobs
Thank you.
said she said.
Thank you.
So one of the things you've testified to is that you've never heard Judge Morrow use inappropriate sexually graphic language. Is that right?
that's correct.
And that you never heard him be discourteous or disrespectful. Is that correct?
That's correct.
And also that he has no reputation for swearing or using sexually graphic information inappropriately.
I agree with that.
And that he has no reputation for harassing attorneys. Is that right?
That's right.
Now, you told us Judge Morrow was a judge for around 25 years, maybe more. Is that right?
I don't know the exact length of time, but I would think it's somewhere around 25. If
Is it
not,
fair to say, I'm sorry, I didn't mean to interrupt you.
I just said if not more.
Okay. Is it fair to say that during the 25 or more possible years that Judge Morrow was a lawyer, that you were not in his courtroom every minute of every day of those 25 years?
I think that's fair to say.
Have you read the complaint in this case?
Yes.
Do you know what the allegations are?
I don't know to recite it, but I know generally what the allegations are.
Okay. Have you ever heard him inject sex or personal, intimate things into his trial or his discussions with lawyers?
I guess the answer would be no to that, unless it's in the context of jury selection, wherein if a factual scenario that's being tried is rather gory or graphic or sexually involved, I can recall, I believe, at least there being some reference to the factual underpinnings of a case so that a jury is aware and not use any preconceived biases or prejudices simply because of the nature of the case. And in that context, he may have been making reference to the graphic nature that a jury is about to hear and listen.
All right, but other than that situation, you've never heard him inject sex or intimate personal things into a trial or into a discussion with lawyers?
Oh, no, I have not.
Would you consider a judge asking two young female prosecutors what their height and weight is to be courteous and respectful?
Well, I don't, it depends on the situation. I certainly, from my knowledge, of Judge Morrow that that if those words are said, that they did not come from a place of disrespect and hurtful and
That's your
place of bias.
opinion about Judge Morrow's state of mind when he said it. Is that fair to say?
I'm sorry.
Is it fair to say that that is your opinion of Judge Morrow's state of mind when he said those statements?
If he said those statements, absolutely.
Would you agree subjectively that it is inappropriate to ask a young lawyer in a courtroom what her height or weight is?
It depends. I can't, not as a matter of course, it may be depending on the circumstance and the interaction of that moment. I don't, I think what may be concern is the person who is involved in it, but my not being in it, I would say that it would depend on the situation and those circumstances, and not so much that a question of height and weight was asked.
In your 44 years as a lawyer, have you ever asked a female lawyer what her height and weight was?
I don't, I can't say that I have. Certainly not, I don't know. I don't think so.
Have you ever said
But,
to a female lawyer, I'm going to assess your body muscle mass?
I can't say that I have.
Would you agree that if you had said those things, that would be viewed subjectively as discourteous and disrespectful?
That all depends because of the subjective it would depend on the subjective context of which that is being raised.
Now, you also told us that you have never heard Judge Morrow swear or use sexually graphic language. And I'm sorry, that he has the reputation of not being one who swears or uses sexually graphic language. Is that fair to say?
Yes, I've never heard anyone say that Judge Morrow's in the courtroom cussing.
Have you ever heard anyone say that he's in chambers cussing?
No.
Were you aware that Judge Morrow has been in trouble with the Judicial Tenure Commission and with the State Court Administrator's Office for the use of inappropriate language? I
don't know what he was previously, as you say, in trouble for. I knew he was in that there had been an ongoing history in Frank Murphy Hall of Justice between the prosecutor's office and Judge Morrow.
Okay, well, the question did not involve the prosecutor's office. The question involved the Judicial Tenure Commission and the State Court Administrator's Office. Are you aware that they have confronted him about his inappropriate use of personal and intimate language with women?
No, I'm not aware of that, but I don't know the source of it either.
So when you formed your opinion that Judge Morrow does not say sexually graphic or inappropriate things to people, were you aware that the State Court Administrator's Office did an investigation and wrote Judge Morrow a letter where it accused him of engaging in, quote, inappropriate personal conversation with a personnel staff person, asking inappropriate questions and making inappropriate personal comments? And that letter was on October 4th of 2004. Were you aware of that?
That they accused him or they made a finding of that?
They made a finding and wrote him a letter telling them their findings.
No, I'm not aware of that.
Were you aware that the letter, same letter I'm referring to, instructed Judge Morrow that, quote, it is inappropriate to discuss matters of a personal nature with court staff unless that individual is an acquaintance or friend? Were you aware that the State Court Administrator's Office instructed Judge Morrow about that?
No.
Were you aware that on April 5th of 2005, the Judicial Tenure Commission admonished Judge Morrow and told him in a letter, quote, similarly, the commission cautions you against engaging in conversations with court staff which are of a personal or intimate nature and which may be regarded as offensive or embarrassing? Were you aware of that?
No.
Were you aware that in a case called People versus Adrian White, case number 18-8430-01. On October 19th of 2018, Judge Morrow asked a hypothetical question in a non-sex related case about whether he would have an expectation of privacy if he were to have sex in a restroom with another male.
No,
Were you aware that in 2018 or 2019, he asked a female prosecutor what color her armpit hair was?
no,
Were you aware that he shared with a female and a male prosecutor that he shaved his own armpits?
no,
Were you aware that in 2000 or 2001, he said to a clerk who worked on the 9th floor of the Frank Murphy Hall of Justice, words to the effect of, "Do you have children? You should have more children. The best time to have sex is when you're menstruating." Were you aware of that?
no,
Would you agree that if all those things I proposed are true, that negates your opinion that Judge Morrow does not use sexually graphic language or discuss personal, intimate things with females?
Judge, I'm going to object. It's a compound question. I don't believe the witness said that. I don't believe I asked any questions about personal matters. So the first half of that question might be okay, but the second half, I didn't ask that.
I'll break it into two, Your Honor.
Thank you.
Would you agree, if the things I just confronted you with were true, that your opinion that he never used inappropriate sexually graphic language might not be correct?
Well, certainly when I say that I'm not aware of it, that's based on my own experience with him. And what is sexually graphic certainly is a matter of those who are involved in the exchange and the interaction and the context in which it is being said. The choice of words in and of itself does not, I think, make it inappropriate, but rather the context and the nature of the interaction.
Does anything that I confronted you with change your opinion about Judge Morrow's, your testimony that Judge Morrow never used inappropriate sexually graphic language?
No,
Now, you also testified that you had never heard him be discourteous or disrespectful. Is that true?
that's correct.
Based on the things I just confronted you with, would you agree that the things listed are discourteous and disrespectful to people?
Again, depending on the context in which those exchanges are being made and the people involved, if the individuals have a particular reaction and response to it, that is something for them to advocate. But I cannot say, without knowing the context and the circumstances in which those words were said, if they were said, would have been inappropriate. So it does not change my opinion.
Mr. Edison, isn't it fair to say that subjectively, no matter what the context, that list of things I read to you are offensive to people and inappropriate?
No, I wouldn't say that.
Now, you also testified that Judge Morrow has the highest of integrity and is the best trial judge in the Third Circuit Court. Is that fair to say?
In the criminal division, right today, I would say he is the best trial judge on the bench today.
All right, now, was that your opinion or is that your reputation testimony?
That's both.
Okay.
Based on my experience and in the defense bar and my interactions with prosecutors.
Would you agree that most prosecutors would not say that Judge Morrow is one of the best trial judges in the Third Circuit Criminal Division?
No, I wouldn't say that.
Do you have a personal relationship with Judge Morrow besides the history that you share?
What do you mean? That is my personal relationship, the history that I shared with him.
All right, well, so maybe I'll rephrase the question. Have you socialized with him in the last 2 years?
You talking about like partying or hanging out or anything like that?
Going out to dinner, inviting each other to your homes?
No, no. We haven't done that.
Do you know his wife and children?
We had a
I'm
50
sorry.
year, we had a 50-year high school reunion. And he was there and I was there. That probably was the first time of like being out in public that we've shared in, I can't even, that might have been the only, I mean, the real time, you know, that was it. Now I would say this also, that Judge Morrow over the years has made presentations in the Michigan Department of Corrections, mentoring the inmates in the correction system on several programs. And I've been on programs with him inside the prisons where we both were in there demystifying the system, encouraging those who have been who have been caged for many years, sometimes caged for life, and trying to uplift their spirits and enhance their quality of life. So I have socialized with him in the prison system. That was a time that I've been outside the courtroom with him, and also at my 50th high school anniversary reunion.
Are you familiar with Judge Morrow's wife and children?
Yes.
How is it that you came to know his children?
His Miss Morrow's office is across the hall from my office. And she, from time to time, the kids were there. And it was like, nah, hey, this is so-and-so and so-and-so. His daughter is a student at Howard University, an outstanding volleyball player on a championship team at Howard University. So being an alumni of Howard University, I certainly embraced her time at Howard. His son had a traffic violation, and I represented his son on a traffic ticket.
Do you have children of your own?
I have 7 children, 16 grandchildren, and 3 great-grandchildren.
Does Judge Morrow know any of your children or grandchildren or great-grandchildren?
He may know my daughter, who used to work in my office and would perhaps file papers in court for me. He may, and certainly if any of the children were in court over the years, Judge Morrow would be a particular courtroom that I encourage people to come in and watch from time to time.
Thank you. I'm sorry.
I'm sorry.
Not just my kids, but any young person who is coming in the court to observe, I encourage them to stop in Judge Morrow's court.
Thank you. I have no other questions.
Judge, I have 2 follow-ups.
Go ahead.
You mentioned that Miss Morrow's office was across from yours. Do you know what profession she's in?
She's a lawyer, trial lawyer, criminal defense lawyer.
Thank you. Can I just have one moment, Judge Widgeon?
Certainly.
Okay. Thank you. Mr. Edison, you mentioned, pursuant to a question by Ms. Weingarten, that there's a history between the prosecutor's office and Judge Morrow. Is that right?
It's the thing, I think it's common knowledge in the Frank Murphy Hall of Justice.
What is that knowledge?
Well, just as the question implied that perhaps most prosecutors have issues with Judge Morrow, I think it's been a longstanding controversy, to perhaps understate it. I don't quite understand the source of it, other than that Judge Morrow exemplifies a high degree of fairness and will hold the prosecutor to task in terms of their responsibilities. And when, as a judge, the prosecutor has not met its burden or advocated their position sufficiently, then Judge Morrow does not hesitate to rule accordingly by way of dismissal or suppressing evidence, and or rendering verdicts of not guilty.
If you know, does this animosity extend to the administration in the office?
I do not personally know, but that certainly is what is the tone in
Well,
the.
objection to the hearsay and speculation.
I'll withdraw the question. Thank you. I have no further questions.
Anything further, Ms. Weingarten?
No.
Thank you, and thank you, Mr. Edison.
Thank you.
May the witness be excused at this time, counselors?
I have no objection.
Yes, you can go out to that lovely weather.
All right, Mr. Edison, I am to excuse you at this time. All right, counselors, we are going back in order then with the that the council is going to call. Does either side?
I'm sorry, Judge, your audio is going out a little bit. I was having a little difficulty.
All right, thank you. Are you able to hear me still at this time, Ms. Jorgensen?
Yes, I can hear you.
All right, let me know if it does go out again. I do have ear piece here that I can wear if I need to. Counselors, we will take, it is 2 minutes of 10, I'm sorry. Let's take a 10-minute break at this time. And then when we come back, Ms. Weingarten, will you be ready to call your next witness?
Yes, I'm wondering if you can tell me whether he's in the waiting room right now. His name is Joseph Curley.
With a K.
All right, I don't see anyone in the waiting room at this time, so maybe you can give him a call or something.
Okay.
All right,
Thank
thank you. 10 minutes, thank you.
hot water for Liz's teeth. Oh, thank you. I'm just coming. I'm just gonna get that.
I think we're ready to continue.
Thanks.
And I do see that Mr. Curley is in the waiting room, so I will admit him at this time.
Thank you, Your Honor.
Good morning, Mr. Curley. If you would unmute your screen, please.
Good morning, Your Honor.
Thank you. My name is Betty Widgeon, and I have been appointed as master in this proceeding by the Michigan Supreme Court. We're going to start with me swearing you in today. I'm going to give you the usual oath, and then I'm going to ask you about the orders that have been imposed with respect to witness protocol and sequestration. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you. What is your name?
My name is Joseph Curley.
And please spell your name, your full name.
JOSEPHKURILY.
All right, thank you. The sequestration order, I'm going to read the portion that has to do with the witness specifically. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceeding before the master concludes. This order prohibits any witness, except while testifying during the proceedings, from discussing his or her testimony in any format or by any means with another witness, from viewing the proceedings on any device, listening to the proceedings on any device, accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to the discovery of the failure or violation. Witness, and this has to do with the amended order regarding hearing and witness protocol. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Mr. Curley, are you alone in the room where you're testifying?
Yes, I am, Your Honor.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notification, including emails and texts, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you understand those orders, sir?
I do understand them. I did not turn my email off, but I'm doing it right now.
Thank you.
Okay.
All right, thank you. And do you swear or affirm that you will abide by these orders until you or unless you are released from these orders or the proceeding is terminated, is ended?
I do.
Thank you. Ms. Weingarten, anytime you're ready.
Thank you. Good morning, Mr. Curley.
Good morning.
How long have you, well, let me ask this. How are you employed?
I'm employed as an assistant prosecuting attorney with the Wayne County Prosecutor's Office
And how long have you been employed there?
since November of 2016.
So 4 years?
Yes, ma'am.
Do you know a young prosecutor by the name of Anna Bickerstaff?
I do.
How well do you know her, and describe for us your relationship with her?
I don't know her particularly well. We would see each other in the office, but I can't say that we had more than a handful of conversations with each other.
Do you know a prosecutor by the name of Ashley Chaffone?
I do.
Can you describe for us your relationship with her?
Similar, I spoke with her a little bit more, and yeah, I guess I suppose I'd have a little closer of a relationship with Ashley than Anna. But again, it's just a working relationship. We don't really speak outside of work.
Are you assigned to any particular unit in the prosecutor's office?
Yes, I am assigned to the General Trials Unit.
Are you assigned to a specific courtroom or a specific judge?
Yes, now assigned to Judge Lawrence. However, prior to that, I was assigned to Judge Morrow's courtroom.
For how long were you assigned to Judge Morrow's courtroom?
I was assigned to Judge Morrow's courtroom from August 2018 until roughly the pandemic struck in March of this year, so 18 months or so.
But you're no longer assigned there now.
I am not.
Were you what they call a courtroom prosecutor?
I am, and I was, yes.
Did you observe Ashley Chaffone and Anna Bickerstaff in trial in front of Judge Morrow between June 10th and June 13th of 2019?
I did.
Did you watch that entire trial? The name of it is People versus James Matthews.
No.
What were you doing in terms of when you weren't watching the trial? What were you doing?
Well, I was probably running around, taking care of my own cases, talking to other attorneys. I did try to watch some of it, but I mean, I didn't watch much of it. I was busy with my own work.
All right. Describe for us during the 18 months that you worked in Judge Morrow's courtroom, describe your relationship with Judge Morrow.
It was a positive, cordial relationship between him.
What was the reason you were moved out of that courtroom, if you know?
I think it was just standard transferring around. I was assigned to Judge Morrow's courtroom probably longer than the average assistant prosecutor gets assigned to a particular courtroom. I think 18 months is probably longer than average. So there's no particular reason that I know of. I think it was just natural moving around that happens all the time.
All right. Did you observe any of the trial of People versus James Matthews?
Some, yes.
Do you remember specific dates and specific events, or do you have just a vague recollection of what went on?
I would say.
I'm sorry.
I didn't hear the answer.
I'm sorry, can you hear me now?
Yes.
Okay, I would say that it was that is a somewhat vague recollection of the specific events and days.
All right. Do you recall seeing Anna Bickerstaff do the direct examination of a police officer where she started most of her questions using the word "and"?
No, I do not recall that.
Do you recall hearing Judge Morrow instruct Anna Bickerstaff about how she needs to fix that problem?
No, I do not recall that.
Did you hear Judge Morrow say anything to Anna Bickerstaff from the bench?
Yes.
Tell the judge what you recall him saying?
Well, there was a moment, I believe you're referencing a moment where from my recollection, it was about lunchtime. So I was finishing up some of my cases before they resumed the trial of James Matthews, Anna Bickerstaff, and I believe the OIC and Ashley Chaffone were all in the courtroom. Anna Bickerstaff said to Judge Morrow something along the lines of, "Was that line of questioning any better?" Judge Morrow said something along the lines of, "Yes, it was, but I have something to say that could make you blush," something along those lines. And then Judge Morrow then there might have been some, communication, but anyway, Judge Morrow got off the bench and sat at the prosecutor's table in the middle of, there was 3 chairs set up at like a prosecutor's table on one side of it. Normally, when I would sit there, there would be 2 chairs because it's really meant for 2 sides, two chairs on each side. But there was 3 chairs on each side, and he sat in the middle chair. And then I heard him, or I didn't hear him. I saw him speaking to Anna. I don't know. I didn't hear what was said.
All right, so your recollection is that he sat in the middle chair?
That's my recollection, correct?
And which chair did Ms. Bickerstaff sit in?
I believe the chair closest to the podium.
Did they have an officer in charge of the case?
Yes.
Where was he during this?
I'm not sure. I mean, my memory is fuzzy for what it's worth, but from what I remember, there were, 3 people at the table. So it was Anna, Judge Morrow, and then I guess either the OIC or Ashley, but I'm not certain who it was. But from my recollection, there was 3 people at the table on the one side.
Okay, sorry. During your testimony today, if you don't have a good memory, say so. And,
Okay.
and don't guess, just tell us you don't know, okay?
All right, I apologize.
All right. No, you're doing fine. We just need to know that you think it's fuzzy.
Okay.
I object to the apology. I don't think it's necessary.
So did there come a time when you saw Judge Morrow and Ms. Bickerstaff at the prosecutor's table talking?
Yes.
Could you describe where their bodies were positioned?
Well, Judge Morrow was in the seat, and Ashley was in the seat closest to the podium, and they were close. But I mean, there was 3 chairs, on
So
one.
I'm sorry, go ahead.
Yes, they were positioned close. All of the chairs were touching armchairs or close to touching, from what I recall. And, yes.
And how close were Judge Morrow and Ms. Bickerstaff's heads to each other?
I don't recall.
Were you able to hear what Judge Morrow was saying?
No.
Where were you when this conversation took place?
I believe I would sit off to the left in the pit, but maybe like 20 or 30 feet away from the prosecutor's table. So it'd be, if you're facing the bench, I would be on the left side of the courtroom.
Near the defense side of the courtroom?
Right, but kind of in a corner. So I'd probably be like, 10 feet off the defense table to the left of it.
All right. Now, by June of 2019, how long had you been assigned to Judge Morrow's courtroom?
It would have been a little less than a year.
During that little less than a year, did Judge Morrow ever say to you, I'm going to tell you something that may make you blush?
No,
Did you ever hear him say it to any other defense attorney or prosecutor?
no,
Were you watching the two of them have their conversation?
yes,
Could you describe for us what they were both looking at?
each other.
Were you able to read anything into Anna's body language?
No,
Were you able to read anything into Judge Morrow's body language?
no.
For how long were they seated with looking into each other's eyes and talking?
Well, they were talking for maybe a few minutes. I don't know if they they were talking for a few minutes.
What happened when the conversation ended?
I believe Judge Morrow got back on the bench and the trial started back up, and I probably went to my office.
All right. During this conversation, were there spectators in
sorry.
the audience?
I didn't hear the end of the answer,
Okay.
and I probably went to my,
I said that after this conversation took place, Judge Morrow got back on the bench and the trial was getting ready to start back up, and I probably went up to my office.
In your 18 months, or I'm sorry, under a year. Well, let's talk about your 18 months as a prosecutor in Judge Morrow's courtroom. Did he ever come sit at your prosecutor's table close to you with the armchairs touching and your eyes locked into each other?
No,
Have you ever seen Judge Morrow do that with any prosecutor or defense attorney besides Ms. Bickerstaff?
Objection. Testimony has not been that the eyes were locked into each other. So foundational.
I can rephrase the question, Judge.
Thank you.
Can you describe what Judge Morrow's and Anna's eyes were doing during their conversation?
Asked and answered. He said he didn't know what their eyes were doing.
I think he said they looked into each other's eyes.
No, he did not. You've said that several times, but he has not adopted that from you.
Objection is overruled. Please restate your question and let's hear the answer.
Mr. Curley, could you describe what Judge Morrow's and Anna Bickerstaff's eyes were doing during their conversation?
they were looking at each other.
Did you ever see them move their gaze away from each other to anywhere else?
I don't know.
All right. So has Judge Morrow ever come down to your table and sat close to you, looking into your eyes and talking about a case?
I mean, he has, yes, sat at the table and talked to me about a case before, after. Yes, he has. I mean,
What side of the table did he sit on?
Sometimes, you know, my side, sometimes standing, you know, in front of the table.
If he sat on your side of the table, were the arms of the chairs touching?
No, but I generally, you know, it's kind of my courtroom. I generally have two chairs on the one side, you know.
Okay, so hold on, you broke up for a minute.
I'm sorry, did you not hear me?
All right, so you're breaking up. You were saying it's your courtroom, and then we missed the rest of that.
Okay, I was basically saying that it is sort of my courtroom, and I would position the chairs how I would like them. I would position the chairs so they were kind of far apart from each other, and there'd be two on one side of the table and two on the other.
So when Judge Morrow would come down to your side of the table to talk to you, were the chairs close together or not close together?
Not close together, generally speaking.
And were your heads close together or not close together?
not close together.
Were there people in the audience while the discussion between Judge Morrow and Ms. Bickerstaff went on?
Yes,
And was the court staff present?
yes,
Do you know a man by the name of William Noakes?
I do.
Who is he?
He was the defense attorney on that case, and he works neighborhood.
I'm sorry, he works.
He works for the Neighborhood Defender Service of Detroit.
Was he part of the conversation that Judge Morrow and Ms. Bickerstaff had?
No,
Do you know where he was when the conversation took place?
I can't be certain. I would assume he was at the table.
I'm sorry, it's breaking up a little bit. Could you repeat that
I might
again?
need to move downstairs because my internet service isn't great up here apparently. So I don't know if you want me to do that really quick, but it will only take like 2 seconds.
Judge, would that be okay?
That's fine. We'll have you go downstairs and will you be on a different internet? I'm sorry, on a different laptop?
No, I'm just bringing my laptop down there. It will literally take me, 30 seconds.
That's fine.
Thanks. Okay, this should be better.
Okay.
And Mr. Curley, I will ask you, are you alone in the room where you are now?
I am. Nobody's in this home at all.
All right, thank you. Continue, Ms. Weingarten.
So you were telling us there were members of the audience in the courtroom when this conversation between the judge and Ms. Bickerstaff occurred?
Yes,
And were the court staff members present?
yes.
Did you have any thoughts about the way the conversation looked to you? Did you think it was unusual, or did you have any thoughts about that?
No. I was interested in what he said, what he was saying, but to be honest, but I didn't really have too many thoughts.
Did you ever ask Ms. Bickerstaff what was said?
I may have.
Do you know for sure, or you're not sure?
I'm not for sure. I'm not certain. No, sorry.
Were you ever told what was said?
Yes.
Were you told by Ms. Bickerstaff or by someone else?
I was told by some combination of Ashley Chiffone and Anna Bickerstaff.
Do you know which day you were told? The same day that you saw the conversation or a different day?
Same day.
Now, did anything else unusual happen relating to that conversation?
I'm not sure I understand the question.
I'm going to object to the form of the question.
I agree, that was a very bad question. I'll try again. How did the conversation between the judge and Ms. Bickerstaff end?
I think that the judge just walked back up to the bench, and then, they were getting ready to bring the jury back in.
All right. Now, were you there after closing arguments and instructions and the jury started deliberating the next day?
I was.
Were you aware that there was an in-chambers meeting between the judge and all the attorneys involved?
I was aware of that, yes.
How did you know about that?
Well, I believe I saw them go back there. I knew that they were back there. I was waiting. I believe I had other cases still up that day while the jury was deliberating. And I was waiting to, handle those cases. And so I was kind of just in the courtroom. And I knew that the four of them, Mr. Noakes, Ms. Chiffone, Ms. Bickerstaff, and Judge Morrow, were in Judge Morrow's chambers.
Do you know for how long they were in his chambers?
I'd say over 45 minutes.
When they returned, did either of the two prosecutors say anything to you? This is a yes or no.
Yes.
Were they discussing what the content of the conversation was in chambers?
Yes.
Did you stay in the courtroom at that point, or did you leave?
I stayed.
Were you present when the jury was getting packed up, ready to leave for the day?
I don't think so, no.
Were you present when Judge Morrow was in the well or the main floor talking with Ms. Bickerstaff and Ms. Chiffone?
No.
Did you later learn that he had had a conversation with them? This is a yes or no. As the jury was getting ready to go home.
No.
Now, the things that you were told, we're not asking you to repeat them because they're hearsay, but did you think any of the statements made to you by either Ms. Bickerstaff or Ms. Chiffone about what the judge said were inappropriate for a judge to say?
I wouldn't have said them. I'd say yes.
Yes, they were inappropriate?
Well, I don't know. I mean, it's not something I would have said. That's all I can really say.
Did you ever consider reporting what you had heard to a supervisor?
Well, no.
Is there a reason you didn't report it to a supervisor?
Well, I kind of had reason to believe that a supervisor already knew about it, because I kind of had reason to believe that a supervisor knew about it shortly after.
What made you believe a supervisor knew about it?
Because in one of the instances where Ashley and Anna were explaining what happened, we were in the hallway, and I believe, Bob Donaldson was there, overheard the conversation, and from my recollection, he said something along the lines of like, a supervisor needs to know about it. So I kind of, from that point on, kind of figured that it was going to be reported somewhere.
Was Bob Donaldson a supervisor himself?
Not really, no, I don't think so.
Now, did you have anything else to do with that courtroom or that trial after the jury hung? That was a bad question. Can I rephrase that? Okay.
Objection, bad question.
Okay.
Go ahead.
Were you interviewed by a man by the name of James Bivens from the Wayne County Prosecutor's Office?
I was.
Do you know how much later after this incident you were interviewed?
No more than 2 weeks.
Did I send you a copy of a paragraph that from Mr. Bivens' report that's attributed to his interview with you?
You did.
besides that one paragraph, did I send you anything else relating to his interview with you?
No.
He wrote a report that is 9 pages long. Have you ever seen his report that's 9 pages long?
I have not.
So besides that one paragraph I sent you, have you read anything else about Judge James Bivens' report?
I have not.
Do you have a copy of the paragraph attributed to your interview in front of you?
It's in my email. I read it before I.
Okay, you don't have to access it unless you need to.
Sure.
When James Bivens interviewed you, who was present?
Just him and I.
Did you tell him the truth to the best of your ability?
I did.
And did Mr. Bivens give you an opportunity to review whatever notes or recordings he took after your interview?
No.
Do you recall whether he recorded you or video recorded you?
If he did, I wasn't aware of it.
Do you recall? Oh, go ahead.
Yeah. No, he didn't, to my knowledge.
Did he have you give a statement in question and answer form on paper?
No.
Do you recall whether he took notes while you talked?
It appeared that he was.
And have you ever had the opportunity to review his notes?
They were sent to me by you a few weeks ago.
All right, so let me go back. What did I send you a few weeks ago?
The paragraph that, were James Bivens' notes, or something that he typed up regarding the conversation he had with me.
All right. Did I also interview you several weeks ago about what you knew about this case?
Well, you interviewed me in February, and we spoke then, and I think we've had a few phone conversations since that February phone conversation.
And since that February phone conversation, have I sent you something I typed up about our conversation?
Yes, you sent me your notes of our February phone conversation.
And did you and I talk about it to make sure it was accurate?
We did.
Right. Besides James Bivens and me, has anyone else interviewed you about this situation?
I spoke to Mr. Campbell over the phone a few weeks ago.
Who initiated that conversation?
Excuse me?
Who initiated that conversation?
Mr. Campbell did.
And did you have any issue with talking with Mr. Campbell about the facts that you knew?
I did not.
Judge, may I have a moment? I'm having phone trouble. Well, actually, Mr. Helland's not available anyways. So I have no other questions.
Thank you. Mr. Campbell?
Thank you. I am ready to proceed if I may, Your Honor.
May.
Mr. Curley, as you mentioned, we had spoken once on the phone, correct?
Correct.
You, in your direct examination, recall the judge as stating that what he had to say could make Ms. Bickerstaff blush, correct?
I thought I said something along the lines of, I wasn't quoting anybody verbatim.
Is it possible that he said it might make her blush?
It's possible. It's possible. I was just giving the general gist.
You did hear, thank you. You did hear what he said, even though your recollection of the exact words may be limited. You did hear what he said, right?
Correct.
Did you take it as a threat?
No.
Did you take it as a concern that what he had to say might make you blush in front of all these people, so let me come down and speak to you more privately?
I can't remember how I took it, to be honest with you.
Is it fair to say that he said things as he was walking down from the bench to the well, in addition to it might make you or could make you blush. He did talk to her about talking to her more privately, correct?
I can't recall.
You were his prosecutor for about 18 months, correct?
Correct.
It was not unusual to see Judge Morrow come down to the well. Is that a fair statement?
That is a fair statement.
In fact, you have been before a number of other judges in Wayne County, correct?
Correct.
All in the criminal division, correct?
Correct.
Fair to say it is rare for any of the other judges you've been in front of to come down to the well.
That's fair to say.
It's also true that Judge Morrow would come to the prosecutor's table from time to time, correct?
Correct.
In fact, I believe you made the estimate of about 20 times that you could think of approximately when we spoke. Do you remember that?
I don't remember saying, I mean, it wasn't unusual. I don't remember saying 20 times, but I mean, it could have been 20 times, I suppose.
Okay. And in fact, it's fair to say you were not surprised to see him come down from the bench into the well and even go to the prosecutor's table on this occasion during the James Matthews trial, correct?
That didn't surprise me.
As you mentioned, there are various ways to design the setup of chairs at the prosecution table in a courtroom, correct?
Correct.
It is the prosecutors who elect how to set up the table at any given time for any given case. Fair statement?
Fair statement.
Judge Morrow empowers the attorneys, at whether they're at the defense table or the prosecutor table, to set up how they want to have their courtroom, correct?
I mean, he never told me I couldn't set it up. I've never seen him say to anybody, change your setup. No.
Give me a moment here. Is it a fair statement that in the time that you served as Judge Morrow's prosecutor, you never saw him purposely try to embarrass anybody?
That's fair to say.
Is it fair to say that there were times where he would talk to you in chambers about things that had happened on the record, that had he addressed them on the record, it would have been embarrassing for you?
That's fair to say.
Objection relevance.
Oh, I'm sorry.
What is the objection?
Relevance.
Objections overruled. Continue.
I'm going to ask the court reporter here, Mr. Curley, whether she received that response, and if so, I'll move on to the next question.
I did, Mr. Campbell. I got the response. That's fair to say.
Thank you. I'll proceed. It's fair to say, Mr. Curley, that you were enabled and able to speak frankly with Judge Morrow in chambers.
That's fair to say.
Fair to say that Judge Morrow would critique you in a direct manner in chambers.
Yes.
Were you in the courtroom during the trial of James Matthews when Ms. Chaffone asked for a critique at the end of the case, to be given at the end of the case? So it was during the trial.
I can't recall.
Is it fair to say that Judge Morrow has an open door policy for his chambers?
That's fair to say.
Is it fair to say that the door is always open when folks are in his chambers?
I wouldn't say always. Most of the time.
Is it fair to say that Judge Morrow calls folks young ladies, young woman, young man, young gentleman, those terms regularly?
That's fair to say.
Fair to say that Judge Morrow in jury trials often uses colorful analogies as he is addressing both voir dire and the instructions for the jurors that are selected.
Yes.
Is it fair to say that although you don't have a photographic memory of what happened in circumstances, it is your recollection that the chairs were touching, but the people were not who were sitting at the table?
Right.
Is it fair to say that not just for prosecutors, but for any lawyer, to be critiqued in the courtroom could be an embarrassing situation?
Sure.
Is it fair to say that on this day that you recall Judge Morrow coming to the prosecutor's table in the trial of James Matthews, that there were a number of people seated in the gallery or in the well besides the folks just at the prosecutor's table?
Right.
You would agree with me that any critique given from the bench would have been excessively communal at that point, and unnecessarily so if what he had to do was give a critique for Ms. Bickerstaff.
Right.
And you recall it's Ms. Bickerstaff who invited Judge Morrow to give her a critique on her questioning of the medical examiner, correct?
Right.
Was it your understanding, let me ask you this, it's true that your understanding was that she sought a frank review as opposed to just pablum? I think that's a word. Do you understand that?
No, I don't.
You don't understand the word pablum, or you didn't understand my question?
That word before, really.
Okay, I'll withdraw it and I'll ask another. I'm waiting for the objection for bad question, which would have been appropriate. You would agree with me that a blush is involuntary, correct?
Right.
Well, objection. He's not a doctor. He doesn't have a psychology degree.
I think it's an appropriate question on cross-examination.
Objection.
Yes, you had an answer.
I'm going to sustain the objection. Do you want to make a separate record?
No, thank you. I appreciate it, though.
Continue.
Thank you. You will agree with me that Judge Morrow and Anna Bickerstaff, let's see, I wrote this down. This is a good question. It's true that they were looking at each other, correct?
Right.
And she was as close to Judge Morrow as Judge Morrow was to her, right?
I don't understand that question.
You were asked how close Judge Morrow was to Ms. Bickerstaff. I'm asking you, isn't it true Ms. Bickerstaff was as close to Judge Morrow as Judge Morrow was to her? Right?
I mean,
let's put it this way. Now I'm going to withdraw the question, ask another. These two people were equidistant from each other, right?
right. I mean, they were,
Judge Morrow was no closer to Ms. Bickerstaff than Ms. Bickerstaff was to Judge Morrow, right?
right.
Ms. Bickerstaff was in an appropriate distance from Judge Morrow for the conversation they were having, correct?
Yes. Yes.
Ms. Bickerstaff was in an appropriate professional distance from Judge Morrow in the conversation that they were having, right?
Yes.
Judge Morrow was an appropriate judicial distance from Ms. Bickerstaff in the conversation they were having, correct?
I'll say that nothing about how they were sitting was particularly, strange to me, if that's what you're asking.
I wasn't, but let me ask you this. Was there anything particularly strange about the way that they were sitting?
No.
I have to ask this just in light of putting in context your direct examination. Did you stare at them the whole time?
No.
I figured you didn't, but I needed to ask. Were you aware of the 404B issue in the James Matthews case?
No.
So you were not aware of the Court of Appeals ruling that came out just before trial?
Oh, I actually was aware of that, yes.
And how did you become aware? Was it through conversation, through something you read? Let me ask you that first before we get into the details.
How did I become aware?
Yes.
Well, actually, I remember on that day there were several different trials scheduled. I had a trial scheduled, and we were all kind of wondering which one was going to go. Me and Ashley were talking about it, and then I remember her saying, well, I have this appeal that the Court of Appeals is going to decide, basically the morning of the trial.
And so it was Ashley Chaffone who made you aware of the 404B issue, and it was prior to trial that she made you aware of it, correct?
Right. And then I was just aware of it as well, just because, I was in the courtroom. Right. So
Let me understand that, Mr. Curley. You were aware of it because you were in the courtroom proceeding. Let me back up, and I'm going to ask a new question, if I may. May I proceed?
There was over-speaking. Judge, I'm sorry to butt in here. Judge Widgeon, there was some over-speaking. I need to mention that.
All right, so let's back up and Jorgensen read to us the last question and whatever part of the answer you were able to get.
Okay. And so it was Ashley Chaffone who made you aware of the 404B issue, and it was prior to trial that she made you aware of it, correct? And the answer was right. And then I was just aware of it as well, just because I was in the courtroom, and that's where there was a little over-speaking.
Mr. Campbell?
Yes, I'm ready to proceed with the next question, if I may.
You may.
Thank you. Mr. Curley, can you explain that to me? Are you talking about the prior 404B motion in May that you were in the courtroom for, or was it during the trial that the 404B matter was addressed?
Prior.
So it was the argument in May. Fair statement?
Yes.
Thank you. Did you ever meet James Matthews? I'm sorry, I didn't mean to say James Matthews. Did you ever meet Emery Matthews?
No.
Can I have just a moment, Your Honor?
Yes.
I'm ready to proceed, if I may.
You may.
Thank you. Mr. Curley, you have the recollection that it was probably Ashley Chaffone who was describing the events at the table with Anna Bickerstaff standing nearby. Is that a fair statement of what your memory is about how you learned about the sum and substance of the conversation?
That's a fair statement.
is it fair to say that in telling you the story at that time, there was no upset by either Ms. Bickerstaff or Ms. Chiffon?
I don't think that's fair to say, no.
You know who you know who Chief Bivens is, right?
Correct.
And you know who Detective Kinney is also, correct?
I do.
Both work for the prosecutor's office, right? Yes?
Yes.
Thank you. You were interviewed by Chief Bivens?
Yes.
How many times in all of your time at the Wayne County Prosecutor's Office have you been interviewed by Chief Bivens?
Once.
You were interviewed about 10 days after the incident on the 24th of June, according to his report. Do you know why there's a 10-day lapse between those events?
I do. I do know why, yes.
Yes. Why was it?
Because I was in Canada and I was on vacation and he tried to call me and I didn't have service and I got back from Canada and I had a bunch of messages from him.
Thank you.
Then so when I got back to work, pretty much, the first thing I did was have to go there to his office.
If you were asked about the accuracy of Chief Bivens' information that was in the paragraph that was sent to you by Ms. Weingarten, correct?
Correct.
If there had been something inaccurate in there, and let's even say something false, if something was falsely attributed to you in there, what would the procedures or protocols of the Wayne County Prosecutor's Office?
Objection, speculation, and there's been no foundation that anything that Mr. Curley said was incorrect or wrong.
Your Honor, this is cross-examination. It is not speculation as to what the policies and procedures would be. And I'm certainly allowed to use a hypothetical with this witness to ask him, what would the policies and procedures of the Wayne County Prosecutor's Office be?
Anything further, Ms. Weingarten?
I think he should be asked if he knows or if there is a policy or procedure.
I think that's a question for direct examination, and this is cross-examination.
All right, I'm going to allow the question continue.
Mr. Curley, do you remember the question? If not, it could be reread.
Will you please reread it for me?
Thank you.
One moment, please. If there had been something inaccurate in that, let's say even something false, something was falsely attributed to you in there, what would the procedures or protocols of the Wayne County Prosecutor's Office be?
I haven't read any procedures or protocols on that issue specifically. So I don't know what the exact procedures and protocols would be according to the policies, because I don't know them off the top of my head.
Would you tell your supervisor?
I would tell somebody that I didn't say that. I would tell somebody who wrote the report, I would think.
So that would be Chief Bivens.
Right.
Anybody else that you would tell?
Probably just him, because he's the only person I've ever spoke to about this other than, Miss Weingarten. I would tell her if she still had the statement.
Did you know what your statement was going to be used for when it was taken?
No.
Were you aware of a motion to disqualify Judge Morrow?
No.
Thank you. The conversation that was taking place and the congregation that was forming in the hallway, as you testified, when Bob Donaldson walks by, how many prosecutors are in that hallway?
Four to six.
Is that in addition to or including Anna Bickerstaff?
Including.
Is that in addition to or including Ashley Chaffone?
Including. I would say that there was maybe, there was a couple other people other than myself, Bob, Ashley, and Anna.
So we're talking 6 to 8 is a fair number?
That would be fair.
And Anna Bickerstaff is telling stories from the trial, correct?
They both were. Ashley and Anna were. I'm sorry.
And when Ashley Bickerstaff was telling her part, she used the word sex at some point in talking about what had happened, correct?
I apologize. You mean Ashley Chaffone?
No, I meant to say Anna Bickerstaff, Ms. Bickerstaff.
I don't know which one of them specifically, said what. It was kind of, they were both telling the story,
Isn't it true, though, Ms. Bickerstaff told the story about what happened at the table because she was the one who was at the table?
She told part of it. I mean,
isn't it true that Bob Donaldson interrupted and took Ashley and Anna away from the group to another place?
I don't recall that specifically.
You recall something else happening, or do you just not have a recollection of how it is that they left your immediate presence in the hallway there with Mr. Donaldson?
Well, I mean, I might have walked away prior to the conversation completely ending. I think I might have left before they did.
Thank you. I believe I have no further questions for this witness. Let me just check my list here. Nope, I've covered them up. Thank you, Mr. Curley.
Thank you.
Ms. Weingarten, anything further?
Yes. Can you describe Ashley Chaffone's body language as she was telling people in the prosecutor's office what had happened?
I would say her body language.
Or her demeanor, her demeanor.
Her demeanor, I would say, was kind of just more like shocked or like, this is crazy sort of thing.
Was she calm or excited?
Excited.
Was she talking loudly or softly?
Loudly.
Are there any other adjectives that you know that would describe how she was acting when she shared with her coworkers what had happened?
would say excited is a apt adjective, I would say.
I'm going to ask you the same question about how Anna Bickerstaff her demeanor was when she shared with her coworkers what happened. What are some words that you know of to describe how she was acting?
Surprised, thrown off, I would say.
Did she appear to be excited?
No,
Did she appear to speak loudly or softly?
softly. She's a little, speaks a little more softly than Ashley does.
They have different temperaments and personalities?
I would agree with that, yes.
Okay. Now, you told us, I believe, correct me if I'm wrong, that there was nothing about how Judge Morrow and Anna Bickerstaff were sitting that was unusual to you. Did you testify to that on cross-examination?
Right, I did.
When you were interviewed by Judge Bivens, did you tell him that Judge Morrow sat next to APA Bickerstaff so close the arms of their chairs were touching, their faces were close as well as he began to talk to her?
I did.
Was what you told Mr. Bivens the truth?
Well, hold on. I didn't say so. Can you repeat that? I apologize.
Okay, I'm going to start over with the conversation. Did you testify on cross-examination today that there was nothing about how Judge Morrow and Ms. Bickerstaff were sitting that was unusual to you?
I did, yes.
Now, did you tell Mr. Bivens when he interviewed you that Judge Morrow sat next to APA Bickerstaff so close the arms of their chairs were touching, their faces were close as well as he began to talk to her?
Right.
Okay, so do you believe that what you told Judge Bivens was the truth?
I do.
And do you believe that a judge sitting with the arms of the chair touching and face close to a female prosecutor is unusual?
Yes, I do.
Has his face ever been that close to you, to your face?
No.
Right. Now, you also testified that you never saw Judge Morrow embarrass anyone on the record, right?
Right.
And that you have talked to him many times in chambers and at the table, and he's given you critiques. Is that fair to say?
That's fair.
Approximately how many times in the 18 months you were in front of Judge Morrow did you have those conversations about critiques and instruction on how to try cases?
Approximately how many times? Hard to say. I mean, I was in there every day, so.
Okay, so more than 5?
More than 5, yes.
More than 10?
Yes.
More than 15?
Yes.
And I'll quit there.
Okay.
In all the 15 or more times that Judge Morrow talked to you about your trial skills and your strategies, did he ever make sexual analogies for you?
No.
Did he ever use the word tease?
No.
Did he ever use the word climax?
No.
Did he ever use the word crescendo?
No.
Did he ever use the word foreplay?
No.
Did he ever discuss sleeping with someone on a first date?
No.
Did he ever use the word fucked or any other swear word?
Yes.
What other swear words did he use?
I said, in this examination that we would talk bluntly with each other. So, I mean, I have to tell you, I would maybe swear back there too.
All right. And no one's judging you or Judge Morrow for that. But is it fair to say Judge Morrow used some curse words also?
Yes.
Did he ever refer to a penis as a dick?
I don't know. I mean, maybe, I don't know. I don't know.
Did he ever joke or make fun of any witness's testimony?
Make fun? No, I don't think so.
Did he ever talk about sex, doing it doggy style?
No.
So he never said any of those things to you when he was critiquing your performance?
No.
On a scale of 1 to 10, how good would you say your memory is of what you saw transpire between Judge Morrow and Ms. Bickerstaff?
I'm going to object. I think that's outside of the scope of my cross-examination.
Response.
Well, he said his memory was fuzzy. I'm trying to establish how fuzzy.
I think he said that in direct, though.
Objection is sustained. Continue.
Judge, I would like a moment to consult with others. My phone has broken, so I would have to step out and use a different phone to make a call.
All
I
right.
don't have an objection, Your Honor.
All right. Let us take a 10-minute break at this time then. Do you need more than 10 minutes to make the phone call? All right. You're not shaking your head. No. Let's take a 10-minute break then. We'll come back at about 10:27. Let's say it's 11. I'm sorry. We'll come back at 11:30.
Thank you. I do have some recross, so the witness will stay.
Yes. Witness
Thank
is
you.
not excused. Thank
Okay.
you.
Thank you.
Cam? Cam? Okay, wait, I need you. I can't get back on Zoom. How do I get back on? This is oh, yeah. How did you do that?
So Laura, just so you know, your audio is on.
Oh, okay. Now everyone knows how incompetent I am with this. Okay, hold on. I want to get my picture back on. So hold on. Start.
Yeah, it was there a moment ago.
Okay. Start video. Oh, there I am. Okay, well, now you all know how incompetent I am with technology.
I think everyone is back and the witness is back on the screen. Ms. Weingarten, continue, please.
I have no other questions for Mr. Curley.
Thank you. Mr. Campbell, any recross?
Yes. Mr. Curley, on redirect, you were asked questions about basically comparing and contrasting the temperaments between Ms. Chiffone and Ms. Bickerstaff, correct? You remember that?
Yes, I do.
It's fair to say that their temperaments and their personalities that they displayed in the hallway of the Wayne County Prosecutor's Office after the trial was consistent with what their personalities and temperaments generally are known to be by you. Fair statement?
I would say, yes, that's a fair statement.
And it's also true that the moment in the hallway is the first time they're back in the office after the in-chambers discussion, which had occurred previously to the jury being excused for the day. Were you aware of that?
I can't say whether that was the first time they were back in the office.
No problem. On redirect, you were asked whether the circumstance at the table, as you remember it, was unusual. And it's true, it was unusual. That's the only time you've ever seen Anna Bickerstaff and Judge Morrow at the table together, correct?
Correct.
On my examination, I asked you whether it was appropriate, and you said, yes, it was appropriate. Even though it was unusual, it was appropriate, correct?
I said I wouldn't do it. I wouldn't have said it. I mean, I don't really want to make I didn't hear the conversation. I don't want to make a ruling on what's appropriate or what's not, you know?
I'm sorry, Mr. Curley. I think I have misled you with my question. I'm interested in knowing about the distance they were from each other when they were talking, not what they talked about.
Right.
That was appropriate.
The distance did not strike me as inappropriate. Right.
Thank you. That's what I wanted to ask.
Yeah.
That's all the questions that I have based on the redirect examination, Your Honor.
Thank you. Ms. Weingarten, do you have another witness to call this morning?
I hope he's in the waiting room.
May I leave?
1 second, please. Our counselors, are we finished with Mr. Curley for today?
Yes.
Yes, Your Honor.
All right, Mr. Curley, before you leave, just remember you are still under the orders with respect to the sequestration.
I understand. Thank you.
Thank you very much. You may leave at this time.
Thank you.
The waiting room, I see Mr. Fishman and Lieutenant Derek Griffin.
Lieutenant Griffin is my next witness.
All right, I will bring him in. All right, Lieutenant Griffin, this is going to ask you to unmute yourself, please.
Your Honor, I have a scheduling question, if I may, before we begin the witness.
Yes.
Your Honor, it's 11:35. It's my expectation we'll get through this witness at or about noon, maybe slightly after. My suggestion is we take the hour for lunch at the end of this witness, which I believe the prosecution is going to close their case. I would begin with my opening statement when we come back from lunch, and I would let Mr. Fishman know that he does not have to wait in the room all the way during lunch and can come back. I will tell him about 1 o'clock, 1:15, depending on when we break here for when the hour lunch ends.
Certainly sounds appropriate to break after this witness. I have no idea how long this witness actually will be, however. So as far as telling your witness what time to come back, I think you'll have to keep that telephone contact with him with respect to that. Ms. Weingarten, any comments?
No,
All right, thank you. Lieutenant Griffin, are you able to hear us?
Yes, Your Honor.
All right, thank you. We're going to start with me swearing you in. I'm going to give you the usual oath, and then I'm going to give you information specifically about witness sequestration and witness protocol for this proceeding. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you. State your name, please.
Derek Griffin.
And please spell that.
DERICKGRIFFIN.
Thank you. I'm going to read first to you information on the amended sequestration order. And I believe I started by announcing myself, but if I didn't, my name is Betty Rankin Widgeon. I have been appointed the master in this matter by the Michigan Supreme Court. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. Sequestration order prohibits any witness, except while testifying during the proceedings, from discussing his or her testimony in any format or by any means with another witness, from viewing the proceedings on any device, from listening to the proceedings on any device, and accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to the testimony. A violation or violations of the order by a witness would be grounds to exclude a witness or to exclude testimony given by that witness prior to discovery of the failure or violation. The amended order regarding hearing and witness protocol includes the following. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room where you are testifying right now?
I'm sorry, Your Honor, I didn't hear.
Are you alone in the room where you are testifying now?
Yes, ma'am.
Thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones or laptops, iPads, smartwatches, or similar devices during their examination. Do you swear or affirm that you have abided by these orders and that you will abide by these orders during the duration of this proceeding?
Yes.
All right, thank you. You may proceed, Ms. Weingarten.
Thank you. Good morning, Lieutenant Griffin.
Good morning.
My name is Laura Weingarten. I'm the one who's been communicating with you about timing and Zoom links and things like that. So tell the judge your occupation.
My occupation, I've been employed with the City of Detroit Police Department since June of 1999.
And what is your rank now?
I'm currently a lieutenant.
Back in June of 2019, what was your rank?
Sergeant.
Were you assigned to any particular unit in June of 2019?
I was assigned to homicide.
Were you the officer in charge of a case called People versus Matthews?
Yes.
Did you attend the trial that occurred on June 10th through June 13th?
Yes.
Do you recall there were two female prosecutors trying the case, Ashley Chiffone and Anna Bickerstaff?
Yes.
Do you recall how the seating arrangements were in the courtroom during the trial?
I was sitting closest to the podium. I can't recall who was sitting next to me. So that would have been the middle seat. I'm not sure who was sitting there or the far right seat.
Would those seats have been filled with one of two prosecutors?
Yes, the aforementioned assistant prosecutors that you mentioned.
Okay. On June 12th, which would have been this, June 11th, the second day of trial, did there come a time during the break that Judge Morrow came and sat at the same table you were in?
Yes.
Do you know why he came down to sit at the prosecutor's table?
I believe a question had been asked as to some of the proceedings and as far as the strategy or the approach by the prosecutor. And I believe Judge Morrow had come down to give some coaching or mentoring.
Do you recall whether he used any particular words as he was on his way down to the prosecutor's table?
As he was walking to the table?
Yes.
I don't recall.
Right. Which prosecutor was he giving advice or mentoring to?
I believe it may have been APA Bickerstaff.
Okay. During that time, where was Ms. Chiffone?
I'm not sure.
Was there a break in the proceedings?
Yes, there was.
Were there people still in the courtroom?
There may have been other staff, but I don't think there weren't any, no jurors or anything were in the courtroom at that time.
What about people in the audience?
There may have been, but I don't recall.
What did you do during the break?
I sat there and Judge Morrow came and he sat at the table.
Which seat did he?
I'm sorry, can you repeat?
Which seat did he take?
I'm not sure if he sat on my side of the table or he was sitting across on the other side of the table.
Where was Ms. Bickerstaff sitting?
She was on my side of the table.
Before the judge came down to the table, describe how the chairs were against when the trial was in progress.
When the trial was in progress, there were 3 seats at the prosecutor's table.
All on one side of the table?
All on one side of the table, and I sat in the seat next to the podium.
Was it crowded with 3 seats behind the table?
It was enough room to maneuver.
Did you see anybody move any of the chairs to the opposite side of the table?
I don't recall.
As you sit today, do you recall where Judge Morrow sat?
I don't. I'm trying to remember, but I don't.
Okay, is it fair to say that your memory of these events is not very clear?
That's fair to say.
Okay, so if you don't know the answer to something, say you don't know, and that's fine. And if you don't remember, say you don't remember, okay?
Okay.
Were you at the prosecutor's table the entire time that Judge Morrow was talking to Ms. Bickerstaff?
I don't recall if I was there for the entire conversation.
Were you there for some of it?
Yes, I was.
And were you paying attention to what they were doing, or were you distracted?
I was listening briefly, and then I began to start doing something else.
Do you know what that something else was?
I may have started to fidget with my cell phone.
Okay. Do you remember what the body positioning was between Judge Morrow and Ms. Bickerstaff?
I can't say that I do. I just know that he was at the table along with myself and APA Bickerstaff.
All right. Do you know how close their heads were together when they were talking?
I can't say that I remember that.
Were you able to overhear any of the conversation?
Yes.
Was it easy for you to hear, or was it kept quiet?
It was fairly easy.
What did you overhear Judge Morrow say?
I remember him saying something with regard to a man and a woman, getting together. And then I remember hearing the word crescendo.
Did you have a feeling or an idea about whether that conduct or those words were appropriate?
I didn't feel that they were appropriate at the time.
Why not?
Because it was my impression that the analogy he was making was in reference to some sexual relations.
Did you feel that was professional of the judge?
No.
Did you feel that would be embarrassing to the prosecutor?
Yes, I would.
Objection to the last question. I don't think that's relevant.
Is there a response, Ms. Weingarten?
Well, it corroborates his impression that it was unprofessional.
All right, let me hear that last question read back again, please, Ms. Jorgensen.
One moment, Your Honor. Did you feel that would be embarrassing to the prosecutor?
Mr. Campbell, you have an objection that it is not relevant?
Yes. How he would feel, whether it would be embarrassing.
Objections overruled. You may answer the question.
Lieutenant, I'm sorry, go ahead.
I would imagine that it may have embarrassed her.
Did you know Judge Morrow before that trial?
Yes, I've had hearings and proceedings in front of him. Yes.
Did you and he get along okay?
Yes.
All right. Did you just strike that? Did it cross your mind that you should interrupt their discussion and tell the judge how inappropriate you thought his conduct was?
I'm going to object. That's a leading question.
Sustained.
Lieutenant, what crossed your mind as you heard the judge's words?
I just thought that this wasn't the setting for that, and for him to be trying to express a point for clarification, he may have used another analogy to get his point across.
What did you think was improper about the words he used?
The comparison to a sexual encounter as a form of a strategy in approaching a criminal case or case.
Did you interrupt their conversation?
No, I did not.
Is there a reason you didn't interrupt their conversation?
I didn't feel that it was my place.
What is the reason you felt it was not your place?
I don't know. Maybe because he's the judge and that's his courtroom.
Okay,
And I didn't think that I had authority over the judge.
all right. Were you interviewed by an investigator from the Wayne County Prosecutor's Office?
Yes, Chief Bivens.
Do you know how much time had passed between the time this incident occurred with the judge and Ms. Bickerstaff and the time you talked to Chief Bivens?
No, I don't recall the time span, but I want to say that it wasn't that long of a time span between the time I was interviewed and the time of the incident.
Did Judge Bivens interview you in person or some other way?
I was interviewed in the, I don't know if it was the 10th, 11th, or 12th floor of Frank Murphy.
Is that the prosecutor's office?
Yes, on one of the prosecutor's office's floors.
Who was present during your interview with James Bivens?
I believe it was just he and I.
Do you know if he recorded your interview in any way?
I don't know.
Did you see him with a video recorder or a tape recorder or any recording device?
I don't recall that. I recall him writing.
Okay, and a piece of paper?
Yes, ma'am.
Did he ever have you sign anything?
I don't recall if I signed anything or not.
Do you know if you ever reviewed for accuracy whatever it was he wrote down?
At the time it was written, I don't think so.
Did he ever ask you to review his notes or anything typewritten for your approval for accuracy?
I don't recall.
Thank you. I don't have any other questions.
Thank you. Cross-examination, Mr. Campbell.
Thank you, Your Honor. Lieutenant Griffin, my name is Don Campbell, and I represent Judge Morrow along with Liz Jacobs, and I'll be asking you some questions. First, at the time of the incident involved here, I should say the time of the trial of People versus James Matthews, you were Sergeant Griffin, correct?
That's correct.
Okay, and you are Lieutenant Griffin today, is that correct?
That's correct.
My intention is to refer to you as Lieutenant Griffin, but if I slip back to Sergeant, it's only because of all the stuff I've read, so I apologize in advance. You were the officer in charge of the case, is that correct?
That's correct.
And this case, at one point, was going to be a case about a murder in 2003 that was supported by other murders that had allegedly been committed by James Matthews, right?
Correct.
And that's something called 404B evidence. Have you ever heard of it referred in that manner?
Yes, sir.
Okay. That's the rule, Michigan Rule of Evidence 404B. If I use terms that you need clarified, please ask me to, and I will do my best to do so.
Sure.
You were aware of a motion that had been filed by the prosecutor's office to include several past incidents of conduct alleged against James Matthews in the upcoming trial, right?
Yes.
And that hearing went before Judge Morrow, correct?
Correct.
Were you there for that hearing? The hearing on the motion, the argument between counsel about whether or not those prior bad acts should be admitted in the upcoming trial?
I don't think I was.
Were you aware of the ruling by Judge Morrow to exclude those events or incidents that the prosecution was trying to bring into the case?
Yes.
Were you aware of the prosecutor's office decision to appeal Judge Morrow prior to trial, what's called an interlocutory appeal? Were you aware of that?
Yes.
Were you aware of the result of that appeal being that the Court of Appeals said that at the time that the evidence is placed in, the prosecution could again request an opportunity to bring in the 404B evidence that had been denied at the original hearing? Remember that?
Yes.
You remember that the 404B evidence sought on appeal was only the 1999 prior homicide. So actually that's the only item that could have been brought in then at trial based on the Court of Appeals order, correct? Did you remember
Okay.
that?
Yeah, I was
Yeah.
I was thinking we went to trial on the 2003.
Yes.
So your reference to 1999, the 1999 case.
Yes. That was the prior homicide that the prosecution was seeking to use when they filed their 404B appeal to the Court of Appeals.
Okay. Okay.
If I were to refer to James Matthews as a serial murderer, you would know what I meant, right?
Yes.
That serial suggests more than two. There were several homicides that he was connected to and that the prosecution wanted to involve in the current case that needed to be tried, right?
Right.
But the only case that was left as a possibility to use from the whole group of them was the 1999 homicide after the appeal. Did you know it was narrowed to that?
I might not have known all of the different hearings or different steps that were taken by the prosecutor's office, but I am aware that there was a 1999 homicide case which he was suspected to have committed.
Thank you. And now we'll talk about what you do, and you might have to help me out with some of the terms. As the officer in charge, you're responsible for marshaling the witnesses for the case. Is that a fair, the prosecution witnesses, is that a fair statement?
Yeah, that's a fair statement.
And in this case, there was somebody named Emery Matthews. Do you remember Emery Matthews?
Yes.
He was
That's
the
his
brother. You're right. He was the brother of James Matthews, correct?
Correct.
And Emery Matthews was endorsed as a witness, correct?
Correct.
And you were responsible for making sure that Emery Matthews would be at the trial under subpoena if necessary, but at the trial at the time that he was called to testify. Is that a fair statement?
That's a fair statement.
Emery Matthews was there for the trial because he was under subpoena, correct?
Correct.
Emery Matthews was not cooperative in the process of this trial. Is that a fair statement?
That's a fair statement.
Emery Matthews had indicated that a prior statement that was attributed to him in 2005 was a statement he would not confirm. You understand what I'm saying, or do I need to rephrase that?
That's correct.
Okay.
His testimony was inconsistent with the written statement.
Not only was his testimony inconsistent, but he had told people before he testified, I am not going to say that my brother made the admissions. Do you remember that?
Yes.
And he had said that the police report that credited Emory Matthews with having made the prior statements was wrong. You remember that?
Yes.
I think he may have even used the word fake or fraud or something like that. Do you remember him being that adamant about how wrong the prior statement was?
Yes, I do recall that.
When, if you can remember, when did you learn that Emory Matthews was not going to testify consistent with the 2005 police report?
I can't say that I recall the exact date and time.
Let me try and see what we can do to get somewhat of a date here. It would have been prior to trial, correct?
Yes.
It would have been close to or before the time when the subpoena was issued for Mr. Matthews, Emory Matthews, correct?
Again, I can't give you the exact date and time, but it was my impression that he wasn't going to cooperate in the prosecution of his brother.
Did you have that impression as early as when the 404B motion was filed? So that would have been sometime in May or April of that year, a month or two before the trial.
Yes, I may have formulated that impression. Yes.
And Mr. Matthews, Emory Matthews, I guess both Emory and James Matthews had a sister. Do you remember that?
Yes.
Do you remember the sister originally was considered or maybe even endorsed as a potential witness to also testify about the admissions that had been made by James Matthews as to one or more murders, correct?
Yes.
The sister, just like James, maybe not just like, but in some manner on her own, the sister had decided that she would not testify consistent with her prior statements to the police, or at least that were in the police report. Is that a fair statement?
That's fair. Yes.
You knew that, like Emory, the sister was not going to testify at trial to the confessions, correct?
Correct.
You knew that prior to trial, correct?
Correct.
Am I correct that you knew that even before or at the time of the 404B motions being filed? Again, I've identified that as May or April, about a month to 2 months before the trial.
I would have known it. Again, I don't know the exact date, but I would have known it prior to trial.
Thank you. And you work for the Detroit Police Department. Is that a fair statement?
That's correct.
You do not work for the Wayne County Prosecutor's Office, correct?
Correct.
But there is a connection or cohesion between the prosecutor's office and the police department, especially on cases that are being tried like this, that you do interact with members of the Wayne County Prosecutor's Office, right?
That's correct.
Your responsibility as the officer in charge is to keep prosecutors abreast of developments that you become aware of relative to witnesses in the case. Is that a fair statement?
That's fair.
Moreover, your responsibility, as you understand it, is to alert the prosecutor when there is a change of circumstances with a particular witness, for example, like Emory Matthews or Emory Matthews' sister. Is that a fair statement?
Yes.
Am I correct that you did alert the Wayne County Prosecutor's Office to the difficulties that were arising or had arisen relative to the testimony anticipated by Emory Matthews?
Yes, I'm sure I had made them aware.
Who at the Wayne County Prosecutor's Office would you have made aware?
APA Chiffon and or APA Bickerstaff.
Thank you. You agree with me that the alert you would have given, let me back up. You agree with me the alert you did give was prior to trial concerning Emory Matthews and his not testifying consistent with the police report?
Yes, it would have occurred because it would have been during my attempts to serve them subpoenas for trial. So yes, it would have been prior to the trial.
You were there in the courtroom when Emory Matthews testified, correct?
Yes, correct.
You heard him deny having made the statements that were attributed to him as of 2005. You heard that testimony where he said no to APA Chiffon, correct?
Yes.
Am I correct? You were not surprised when you heard that. That went the way you expected it to go based on the information you had about Emory Matthews.
Yes.
Were you ever advised by either APA Chiffon or APA Bickerstaff that a 404B motion would not be made before the close of proofs?
A 404B motion would not be made. What was the end of that question?
Before the close of proofs in their prosecution.
That I don't recall.
That's not necessarily something they would have spoken to you about, correct?
They may have, but I may or may not have recall that. A lot of times I don't get overindulged into what the role of the prosecutor is as far as all of the legal aspects of the case.
Thank you. To your knowledge, in that room on, I think we've agreed July 11th, 2019, however many people may have been, June, thank you, June 11th, 2019, however many people there may have been in the courtroom, to your knowledge, you were the only one with a gun, right?
If the sheriff's department personnel were in there, then they would have also been armed.
All right.
But
Thank you.
Yes.
How did it feel? Thank you. Give me one. Certainly at the table, you were the only person with a gun. Fair?
Fair. That's correct.
Thank you. If I may ask the master just for a moment here, I believe that I have finished my examination. I want to make sure.
Certainly.
Want to go farther?
I think I am ready if the witness is ready and with permission from the master.
Certainly.
Thank you. I have a couple more questions. I'm going to ask you, Lieutenant Griffin, what is the usual amount of time before a murder case that you serve a subpoena?
Can you repeat that question?
Yes. What is the usual amount of time before a murder trial that you serve a subpoena?
Really, there is no set time, but generally like to get the subpoenas out as early as possible.
Fair to say that for witnesses who are thought to be more difficult than others, you would like to get those subpoenas out first or, again, well in advance of the trial, correct?
That's correct.
So Emery Matthews would qualify as one of those people that you wanted to serve for sure because you knew he was going to be an issue at trial, correct?
Correct.
So is it fair to say that at least 2 weeks prior to trial, and the trial is June 10th, at least 2 weeks prior to that, Emery Matthews would have been served?
Are you asking me if that was the date he was served?
I'm asking you if it's fair to say that he would have been served at 2 weeks or more before the trial.
To be honest, I don't recall when exactly he was served. But when he was served, he would have placed his signature, date and time on my copy of the subpoena.
And where would your copy of that subpoena be today?
It would be with the case file. Should be with the case file.
The case file at the prosecutor's office or the case file at the Detroit Police Department?
At the Detroit Police Department.
Would you have access to that?
I've been transferred out of that unit, but I possibly could have access to it.
Thank you. There was an Officer Tessio who was endorsed as a witness in the case. Do you remember the fact that Officer Tessio was an endorsed witness?
I remember him being a witness, yes.
Do you remember to what it was that he was a witness? To what he was a witness to, maybe.
I can't recall now.
Am I correct? He was not a 404B witness.
That I wouldn't know, sir.
Thank you. I have no further questions for this witness. Thank you, sir, for your time.
Thank you. Any further questions, Ms. Weingarten?
No, thank you.
Thank you. May this witness be excused.
Yes.
He may be excused. I'd like to reserve the ability to explore the date of the subpoena and its service. That might be something that we can even stipulate to. But in terms of his testimony right now, I have no objection to him currently being excused with the admonition that he might be recalled.
All right, thank you. Lieutenant Griffin, I am going to excuse you at this time. And remember, you're still under the order with respect to sequestration. All right.
Yes, Your Honor.
Thank you. You may leave the meeting at this time, the hearing.
Thank you.
All right, it is 12:13, and this appears to be an appropriate time for the break. Lunch break.
If I may, before the break, if the disciplinary counsel is ready to close their case, I'd ask that that be done, and I'll be then ready to begin with my opening.
Ms.
Judge, would you like me to do that now, Judge?
You certainly may if you want to do that. It's we haven't run too far over the lunch hour. Go ahead.
The people rest.
All right, thank you. At this point,
Oops, I'm sorry. Sorry, I misspoke. I'm so used to being a prosecutor. Disciplinary counsel.
All right, thank you. Is there anything further before we take this lunch break?
Not for disciplinary counsel.
I see that Mr. Fishman is in the waiting room, so I'm not sure what time you want him to be back, but Mr. Campbell, you'll let him know that we're on the
He will be, and I'll let the guard know, he will be our first witness. Depending on his length, we will either then go to Mr. Noakes or to Detective Kinney, who is anticipated to be here around 2 o'clock. So that's where we plan to go with our next 3 witnesses, and then we can update you as we go along.
All right. We will come back at 1:15 then, please. Thank you.
Thank you.
Thank you.
I've alerted Don't forget.
We're on the mic. Laura, can you hear me?
Yes,
Thank you. The stuff that we have traded by email
yes.
today, you want to find some time tomorrow or Friday, whichever is more convenient for you, to
Sure.
continue those discussions? Okay, thank
Sure.
you.
It looks as if everyone is back. See, Mr. Campbell's mic is still on mute.
No E. We're on live here.
Yes.
Good afternoon. I think we are ready then to begin with your opening statement, Mr. Campbell.
Thank you, Your Honor. So I have to confess, I can't think of the last time that I withheld an opening until after proofs. You've seen much of what I have anticipated the proofs to show. There are still obviously some proofs to come from our side, but I'll do my best to stay forward-looking as opposed to arguing about what you have seen. I'll try to highlight a couple of themes that we've already established and that I believe our case and our witnesses and our evidence will continue to support. One of those themes, Your Honor, is that there is an inconsistency between the presentation of the information by Ashley Chiffone and Anna Bickerstaff. Where those two individuals are in the same place at the same time and have provided evidence, the proofs will show that Anna Bickerstaff is far less credible than Ashley Chiffone. Moreover, the proofs will show that Anna Bickerstaff is untrustworthy in any of her recollections related to matters where somebody else was there as a witness. As an example, when you review the evidence in this case, you are going to find, I'm going to grab one demonstrative aid for me. You're going to find a description, and you've already heard this in testimony, but further the proofs are going to show that the description of what occurred in chambers is vastly different by Ms. Chiffone than it was for Ms. Bickerstaff. Ashley Chiffone's recollection is, essentially she wrote in her memo, the judge said, quote, "Oh, so he's claiming that what he's working with will cause a miscarriage." okay. Ms. Chiffone doesn't have any of the obscenities that were alleged by Ms. Bickerstaff. You're going to hear the testimony of William Noakes. You're going to find that Mr. Noakes doesn't support the information that Ms. Bickerstaff testified to. Again, there are 4 people in the room. And only Anna Bickerstaff put certain words in Judge Morrow's mouth. The prosecution says that their case is about people who felt powerless. Judge, it's about people who have tried to act powerful. It is about people who are in a courtroom where Judge Morrow does his best to make everybody equal, to come down into the well when he talks to the jury, to sit down next to the prosecutor rather than lord and stand up above, to bring the head closer to her so she can hear him, but also bring their levels appropriate socially, judicially, and everything else. And yet, in the back in this conference, where they are without stripes talking to the judge, the walk away from Ms. Bickerstaff is to create words and circumstances that are vastly different than the other people in the room's recollection. In particular, Ms. Chiffone places the statement that she has in her memo that she testified to. Remember, Ms. Weingarten tried to get her to say certain words. And she said, no, I can't say that I remember those words being said. Ms. Chiffone places the wording that she does recall in the context of a question about the prosecutor's theory of the case, not in a position where Judge Morrow is making fun of the defendant. A vastly different context. And it's born out of Ms. Chiffone being far more accurate than Ms. Bickerstaff. It's born out of Ms. Bickerstaff lying. I say that because what we've learned, and again, it was not something that I had information about before the case started, but what we've learned is that Ashley Chiffone and Anna Bickerstaff met with Detective Kinney. It was not Chief Bivens, but it was Detective Kinney. And it was Detective Kinney who had each of them review the information that Detective Kinney separately took from them in her interviews, and then had them sign a document that said this was accurate. The information that was on that document that was signed as being accurate included the statement that from Ms. Bickerstaff that Judge Morrow was hitting on her. Now we know from Ms. Bickerstaff that she says that absolutely isn't true. That's what she's testified to here under oath. I don't believe you're going to be able to make a determination that her testimony here is consistent with what she told Detective Kinney. It is our theory of the case that what happened here is 2 prosecutors ended up in an argument, as they concede in their early memos, but then walk away from in their affidavits, in an argument with a judge in chambers. It is not one-sided, as Ms. Chiffone says. Here she's not correct. It was, in fact, her arguing along with Judge Morrow. What she failed to see is Judge Morrow's purpose was to point out the errors in the case, to make her a better prosecutor, to make her understand why they were errors in the case. She took those as personal offense. She reacted in that way. She told you that she was protecting her case. I believe the proofs are going to show overwhelmingly she was offended by what happened. Interestingly enough, the proofs are going to show that Ms. Bickerstaff wasn't. That for all her claims that have come out since, when they walk from the chambers into the courtroom, when the jury is released, the proofs are going to show that when Judge Morrow makes a statement that's related to what he talked about in the voir dire, related to this concept of tall and size, he is met with Ms. Bickerstaff having heard the guess on the height, which she concedes and Ms. Chiffone concedes is way off. He has overestimated, because he did not overtly eye, he overestimated the height. The point was not to say an accurate height. The point was to refresh and remind them that this is about things in terms of your own size as a person. How do you see yourself? And Ms. Bickerstaff, her reaction that she concedes in her memo and even in her testimony, what does she do? She says to the judge, oh, I'm 5'3", if that's helpful. For two prosecutors, when prompted by this prosecutor, in this case, who say, oh my gosh, I thought it was terrible asking me about my height and weight, what does Ms. Bickerstaff do? She invites a second round of guessing from the judge. It is outrageous that they would come in here and say, oh, we were offended by that. The judge then guesses their weight, which again, equally generous and kind in doing so. I believe that was the testimony of Ms. Chiffone on that. And I believe that the memo from Ms. Bickerstaff even says, oh, judge, that's kind, or that's generous, or some words to that effect. Somebody says, oh, you shouldn't guess somebody's weight or a woman's weight in particular. The prosecution is, in this case, is run this line between, well, you treat all prosecutors the same, but oh, wait a minute, there's special rules for female prosecutors. I think you're going to find here that the judge, in his addressing to these prosecutors, had reason because he was invited each time to make an assessment, to make a critique, and to make a review at their request. Each and every, even judge, I'm 5'3", if that's helpful. Each and every time it is in response to them. They admit to wanting the review and the assessment at the end of the case. They are getting assessments through the case. Again, not that they recognize it or appreciate it, but they're being told how to try the case appropriately. And in doing so, they will try the case better. Even it is Ms. Bickerstaff who asks the judge, did I do better? There's no evidence that she recoiled, that she tried to stop the judge. In fact, it's a conversation even by her own hand in the memo. As you know from our answer, it's our position that she doesn't get the wording right, even though she tries to put it into a transcript style. But the essence is an analogy, as Detective Griffin testified, an analogy that does use sex as the basis for the analogy. And judge, it is right as an analogy. I believe Ms. Bickerstaff had to acknowledge this as well in her testimony. The proofs are going to show that the analogy to the medical examiner is not a flawed analogy. It's the right analogy. Are people mature enough to hear it? Are people mature enough to understand it? I submit to you that Judge Morrow believed reasonably, based on the interaction to that point, that they were. And that interaction creates a basis for the interaction back in chambers, and that creates a basis and a foundation for the interaction when the jury is dismissed. Another theory of this case, which I believe we'll be able to establish through the evidence, is that these two prosecutors go back to the office and they're telling war stories. And they're the hero in these war stories. And they have gathered around them 6 to 8 prosecutors. And they're telling the story in the hall, and they're embellishing that story. Remember, they told this story a number of times before anybody went to write it down. They tell the story and they say it loud enough, and I believe you're going to find they say it proud enough, that it catches the attention of Bob Donaldson, who's walking by. I believe the proofs are going to show that as he's walking by, he hears the word sex, and he goes to this gaggle of prosecutors, finds the folks who are saying it, he takes them. They don't say, hey, Bob, you know any superiors we can go talk to? He takes them, and now it's serious. And now this little story, this big fish story that they've told has become a big deal. And what do? We know in the circumstance of Anna Bickerstaff that what she does is she embellishes it more. The proofs are going to show in the course of her statements to Detective Kinney. I believe Detective Kinney's going to say, I wrote down what I wrote down because that's what I heard. Moreover, she's going to talk about Anna Bickerstaff being emotional during that time. The proofs are going to show that she's emotional, but she's emotional because she's lying, not because she's telling the truth, and not because of the truth of what happened. Judge, the witnesses to be called, if I have a moment. You've already heard the character testimony from Jeffrey Edison. You're going to hear more character evidence from Stephen Fishman. We have Nicole James, who has the experience both as a prosecutor and as a defense attorney. And again, this may not be the order in which they're called. William Noakes, the defense attorney, who's going to be here. I believe he's going to testify, Judge, that he is a minister. And I believe he is going to say that the wording that Anna Bickerstaff attributes to Judge Morrow, he does not recall. That he does recall that there was back and forth, and he does recall that the prosecutors gave as well as they got. Gabby Silver will testify, Judge. She is an attorney in a case that was disqualified from Judge Morrow. She's going to talk about the circumstances of that. And again, it's going to be, you're going to hear that this case was disqualified from Judge Morrow without an ex parte motion being filed, without notice. What she got was notice that it had been already turned over to a new judge, Judge Hathaway, a visiting judge. You're going to hear from Lillian Diallo, again, another defense attorney. And you're also going to hear from Joan Hughes, who's the former secretary of Judge Morrow's from back in the early mid-2000s. In particular, I highlight the anticipation of her proofs. You've heard about the letters that were written in that same time frame. Ms. Hughes, who has an experience during that time frame at Judge Morrow's chambers, is going to say that she left employment with Judge Morrow. And I believe the testimony is going to be that while she's at home, while she's somewhat desperate for new employment, she gets a call from Wayne County. And the caller says, we have a job for you if you want to come back, so long as you have dirt on Judge Morrow. You're going to hear, Judge, that in this case, the principals at the Wayne County Prosecutor's Office saw in the Bivens report the opportunity to have another round with Judge Morrow. And it's based on the lie that Anna Bickerstaff has made. And if you find that she never said this to Detective Kinney, she has the problem of never correcting it, which is a serious flaw alone that would require you, I believe, when all the proofs are in, to discard all of her testimony. And if you find that she's lying now when she says that she didn't say these things to Detective Kinney, the problems are no less, and the problems for the prosecution are no less. Reality is, without that line in that memo, we're probably not here today. Thank you.
Thank you, Mr. Campbell. Your first witness, I believe you said, is Mr. Fishman. Is that correct?
That's correct.
All right. I see Mr. Fishman is in the waiting room, so I will admit him at this time.
Hello?
Good afternoon, Mr. Fishman.
Yes, ma'am.
Thank you. My name is Betty Rankin Widgeon. I am the master for this particular proceeding appointed by the Michigan Supreme Court. I'm going to start by swearing you in, and then I'm going to also mention information with respect to the sequestration order and the order regarding hearing and witness protocol. Are you able to hear me all right?
Yep,
All right, raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you. What is your name?
Steve Fishman.
Thank you, and please spell that name.
Steve, S-T-E-V-E, Fishman, just like it sounds, F-I-S-H-M-A-N.
Thank you. Mr. Fishman, the first order has to do with sequestration of witnesses. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. Sequestration in this case prohibits any witness, except while testifying during the proceedings, from discussing his or her testimony in any in any format or by any means with another witness. From viewing the proceedings on any device, listening to the proceedings on any device, and accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to the discovery of the failure or violation. With respect to the amended order regarding hearing and witness protocol, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Mr. Fishman, are you alone in the room from which you are testifying?
I am.
Thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Right, so at this time, I will ask you, do you swear or affirm that you have followed these orders issued by the master?
I have.
And that you will continue to follow these orders unless and until you are released from them or that the proceeding has been completed?
I will.
All right, thank you very much. Ms. Jacobs, anytime you're ready.
Thank you. Mr. Fishman, can you tell us, first of all, where you're located right now?
I'm in my office, 615 Griswold. It's the Ford Building, Suite 1120.
What is your profession?
A lawyer.
Can you tell us a little bit about yourself, your background, your schooling, and your practice?
I was born and raised in Northwest Detroit, Bagley Elementary, Hampton Junior High, Mumford High School, class of 66. Went to the University of Michigan from there, played on the basketball team, graduated in 1970. I got a high number in the first draft lottery, which enabled me to go to law school. Wayne State, I graduated in 1973. I went to the defender's office where I had worked for about a year and a half as a researcher. I started there in November of 1973. I worked there until May of 1976. I then went on my own, and here I still am 44 years later on my own as a criminal lawyer.
Thank you. Can you, at the time that you were at Mumford, were you there at the same time as Bruce Morrow?
Now I always refer to him as young fella, he and Gerald Evelyn. They were younger than me. They were in junior high. They went to Mumford with my sister.
Were you there at the same time as Jeffrey Edison?
No, his older brother and I were dead buddies, but Jeffrey was also, I think, in my sister's class of 69. I think Bruce and Gerald were a class of 70. I'm pretty sure that's accurate too.
You indicated that you worked at the defender's office. Can you tell me the nature of the practice at the defender's office? And incidentally, is this a different defender office than the iteration that we have now?
Yes, the one now is the NDS. I happen to be on the board of it. It's a national office. It's based in New York, and it's completely different from what we had. The defender office then was created after the riots. Mizell Sowell, that's M-Y-Z-E-L-L for the reporter, S-O-W-E-L-L. Mizell was the chief defender, and we had a very eclectic group of people that worked there. We had court assignments only from Recorder's Court, which in those days was still the court of the city of Detroit. And we also had a unit that worked in criminal cases in Wayne Circuit Court, which would have been the city county building. Those were Wayne County cases outside the city of Detroit. We were supposed to get 25% of the assignments from the judges of the court in Recorder's Court. Some judges went exactly by that. Some judges went better than that. And some judges didn't give us a whole heck of a lot at all. So we represented indigent defendants, I guess is the best way to say it.
Would you have been in Recorder's Court every single day in your practice at the defender office?
Unless I was sick or on vacation, we were there every day.
Would you have more than one case per day? Let me, go ahead.
We had what we call a day sheet. The reason I became really familiar with that is that the last 6 months or so that I was there, I was the chief deputy. The day sheet had a list of the cases that were up for the day, and we all had our names on it, and they would put what cases we had, and we tried to cover all of them ourselves. I generally was able to do that, but oftentimes you'd be covering, if you were in a trial in front of Judge Geraldine Ford and somebody had a sentencing, you may wind up handling the sentencing in there. So yes, we certainly had a lot more than one case per day, that's for sure, even if you're in a trial.
If you were in a trial and you had a case in another courtroom and no one would cover it, would you have to take time out from the trial to go and do your work in the other courtroom?
I've always been, and I was back then, even though I was a young kid, I was a big believer in the continuity of representation. And a lot of us were, but I really was a big believer in it. So I would let the judge know that, you know, I've got a pretrial or I've got a sentence. And I have to tell you that almost every judge, and we had plenty of, I don't know if I would call them right-wing judges, but we had plenty of not so liberal judges back in those days. That was before the city had changed as much. And almost every judge let me do it. I can rarely think of a time where I was forced to just sit in the courtroom. They'd let me go if I was 5 minutes late coming back. They were fine with it.
Can you tell us a little bit about the culture of Recorder's Court?
Back in the 70s? Or in general?
Let's do it in general. First of all, has it changed much since the 70s when you were practicing there every single day?
I don't think you could overemphasize how much it has changed. And we have to keep in mind that in the last at least 5 or 6 years, maybe more, I do almost all my work in federal court. And that's by choice, not by that I was excluded. In the 70s, there couldn't have been a better place on the planet to learn how to be a trial lawyer than Detroit Recorder's Court. And it was good for everybody. It was good for the defense lawyers, even if they came up like Bruce and I and Jeff Edison, where we came from school like Mumford, where we lived in mixed neighborhoods. We'd obviously been around black and white people. It was also good for prosecutors, many of whom became very good friends of mine, who were regular white guys who'd never really been around black people. And they had to learn how to relate and speak with black folk. And far as I was concerned, you could not possibly have had a better experience learning how to try a case than being in recorder's court in those days.
Would you please stop rocking in the chair? Thank you. Did you ever
Sorry,
ask,
Judge.
did you ever ask a judge for criticism or critique of your performance?
When I started as a lawyer in November of '73, Chuck Rabbits had become a judge in '72. He was a lion of the defense bar. And I can remember in those days, recorder's court judges handled all parts of the cases. They arraigned, they did preliminary exams, they did the trials, they did the sentencing. And we were all assigned to preliminary exams to begin with when you started in the defenders. And I asked Judge Rabbits to give me a critique. I mean, I was new and I'd been in the courtroom a lot because Mizell allowed us to go and watch some of the better lawyers when they'd have a trial. And I asked him to do that while I had exams. I had exams in there. I want to say it was a week or 2 weeks that they would have them. And I wanted to hear what he had to say. And
Judge, at this time, I object to this line of questioning. While the stories and history are really interesting, they don't really have anything to do with our case. So I would object to relevance.
Excuse me.
Go ahead.
Judge,
Respond.
yeah, this is a character witness, and I think that in order to judge the believability and the credibility of his evidence, you must also believe in the credibility of Mr. Fishman. So you must know a little something about him other than I stuck another attorney up in front of the camera.
Anything
It'll
further?
be, no.
Ms. Jacobs, were you going to say something else?
Yes, I was just letting you know we're pretty close to ending this chapter in Mr. Fishman's testimony. I just wanted to finish with asking for criticism.
All right, I'm going to let you continue at this point. Go
Thank
ahead.
you. Mr. Fishman,
go ahead.
did you make it a practice of asking judges for criticism?
Not really. I can't remember. I probably discussed it with Judge Samuel Gardner as well. I probably said something to him. It depended on what I thought of the judge. I mean, some of the judges, I wasn't really interested in what they had to say because I wasn't all that impressed with some of the judges. But I know I did it with Judge Rabbits, and I think I did it with Judge Gardner because I thought he was an excellent judge.
Mr. Fishman, are you a recipient of the Gilman Award?
Yes.
Can you tell us what that is?
An award that's given in federal court, one person per year. It alternates in general between somebody from the defense bar and someone from the government.
And what is it in honor of? What is it for?
Lenny Gilman was a Oakland County and Wayne County prosecutor. He became the United States Attorney. He's one of the great people you ever met in your life. And he passed away suddenly and unfortunately at a young age. And the Federal Bar Association, which is the one that gives the award, decided to inaugurate this award and name it after him.
And what is it an award for?
Just for being a good lawyer in the federal court is all I know about it.
And the people in the Bar Association, are they both prosecutors and defense attorneys or just defense attorneys?
No, there's both prosecutors and defense lawyers. And what happens is once you've been given the award, you can come to the meeting. Used to be a lunch meeting before the pandemic, obviously. And they would kick it around as to who they thought might get it this year and then every year following.
Have you also served on merit selection panels?
In federal court?
Yes.
Yes, I've been on the magistrates. I'm on one right now because we need to appoint a new magistrate, and I've been on one for the United States District Court as well. I've been on more than one.
Thank you. Turning your attention to the reason why we're here today, do you know Judge Morrow?
Yeah, I've known him for a long time.
Can you tell us a little bit about your interaction with him?
Well, I left Mumford High School, a class of '66. played on the basketball team. We had a very successful season our senior year, and our coach obviously stayed when we left. When I was at Michigan, my sister, who started in 10th grade, when I went my freshman year, started telling me about friends that she had made there, and Bruce was one of them. And it turned out that he played on the basketball team. He played for the same coach as me, and they actually won up to us. We lost in the quarterfinals, they lost in the semis. And I know a couple of my teammates and I came to Bowen Fieldhouse in not East Lansing, in Ypsilanti to watch them lose in the semis. I was kind of hoping they were going to win, but that's what happened. So I've known him ever since then. We've played in basketball leagues together over the years. His wife and he and my wife and I are friends. We played in out of town where the wives went to, and a couple other guys playing in 3-on-3 tournaments. And we've been friends for a long time. The Mumford connection, as anybody will tell you that went to Mumford, particularly in the 60s and 70s, is very strong. We have a picnic every year called the 8 Mile Reunion. 1,000 people will show up. So if you're a Mumford person, particularly if you play basketball, you're going to stay friends for a long time.
Mr. Fishman, let's turn to your experience with Judge Morrow as a judge. Have you practiced before him?
I have.
How would you describe the atmosphere in his courtroom?
I would say that the atmosphere in his courtroom is very friendly. I think that Recorder's Court in general is a lot more informal than most of the courts I've been in. Not every single judge, but many. And I think, I know anybody that you asked about the experience in his courtroom, the first thing they're going to say, particularly if they're a defense lawyer, is he gets started every day at 8:30, which defense lawyers really, really appreciate, because we spend way too much time standing around doing absolutely nothing, waiting for judges to get there at 9:45, 10:15, or who knows when.
Can you tell us, can you describe Judge Morrow's voir dire practice?
Judge Morrow, as I say, is informal, and he believes in making people comfortable. All of us who've been trying cases for a long time know that jurors who come to court in general are not very comfortable. It's a strange place for them. A judge comes out, he or she's got a robe on. The people are always telling them, stand up, sit down, go here, go there. And I think that Bruce's thing always has been to try to make people, comfortable. And he does a very good job of that. He comes off the bench, he stands there in front of them. He introduces himself as Bruce. He doesn't talk about I'm judge. Everybody knows he's judge. He's got a robe on, but he makes them as comfortable as he can. So that's the first thing that you notice in voir dire. The second thing is, I think Judge Morrow, like anybody that's tried a lot of cases, recognizes that in voir dire, what you're trying to find out about people is whether they have bias. And bias doesn't necessarily mean I hate somebody or that they are a member of the Ku Klux Klan. Bias can be conscious and bias can be unconscious. And Judge Morrow makes a very fine attempt to get from the jurors or to explain to jurors what bias is, and then to ask them questions that cause them to show one way or the other, or even to acknowledge to themselves that maybe they are a little bit biased about this. Maybe they don't like left-handed guys. Maybe they like tall people better than short people. I think he learned a lot of that from Judge George Crockett III, who did the exact same thing and was a fantastic voir dire person. I would say in my career, a couple hundred jury trials at least, I'd say the two judges I thought did the best voir dire that I've been in front of were George Crockett III and Bruce Morrow.
Do you have an example of Judge Morrow's voir dire involving bias and perception?
I think that I have an example for sure. And I think that what he tries to do is to get people to realize that a lot of things are subconscious. So what did he do? We were trying a homicide case, if I'm not mistaken, and he was voir diring, and we had a mixed jury of white people and black people. And he picked a guy, I think he was from Livonia or Lincoln Park somewhere, and he had him stand up and they were talking about whatever. And he was asking him just about the notion of bias. And then he told me, Mr. Fishman, stand up. So I stood up and he was standing up in front. And he looked at the guy, I don't remember his name, but let's say Mr. Johnson. Between the two of us, between me and Mr. Fishman, who played basketball at the University of Michigan. And you could see the guy he looks at Bruce, he looks at me, and he goes, "You, Judge."
Before you finish, can you tell us how tall you are? Because you're sitting down and we can't see that.
Program height or real height? Program height 5'10". I don't think I was ever quite 5'10". Probably 5'9 3/4. Now,
And
in my
how-
old age, I doubt I'm that much anymore.
And how tall is Judge Morrow?
6'4", I would say.
Okay.
He rebounded, I shot. That's how it worked.
Now finish your
So-
story.
So, the
All right.
juror looked.
Just one moment. We're having a little bit of over talking, and I can see from the court report she's not able to get all of the answers. Would you please read back the last question and answer that you were able to get?
The full that I got was in how tall is Judge Morrow? 6'4". That was as far as I got.
All right, Ms. Jacobs, if you would repeat the question that you were trying to ask after that, please. And I would just ask you both to wait until the other one is done with the statement before you jump in with the next answer or question.
My apologies, Judge. I think I'm the one jumping in. Mr. Fishman, would you finish your story now about Judge Morrow and how he teaches unconscious bias to people?
So the white juror said, "You, Judge, you must have been the D1 basketball player." And the judge looks at him, he says, "And you think that because I'm tall and Mr. Fishman is shorter?" And the guy said, "Yeah." And then he said, "But in all seriousness, part of your thinking is that I'm black and Mr. Fishman's white, correct?" And the juror kind of chuckled and, "Yeah, Judge, yeah, you're right." And the judge said, "Because you watch the NBA and 85% of the players are black." And the juror went, "Mm-hmm." And then he says, "Well," he said, "Mr. Fishman, you can sit down. I just want you to know you're wrong. Mr. Fishman's the one who played at the University of Michigan, not me." And you could see the look on the juror, and then he proceeded with other jurors, and his point was well taken, having nothing to do with me being a basketball player, just that people have unconscious biases that are not the type that come out necessarily, and they certainly don't come out if you have a judge who just reads through the voir dire questions that are contained in the jury instructions or wherever they get them from.
You have had, obviously, the opportunity to observe Judge Morrow interact with jurors, correct?
Correct.
Have you ever observed him to be discourteous or disrespectful towards jurors?
No, it's exactly the opposite. He greets them when they come in, at least in the cases that I've had.
What do you mean he greets them?
He's there, he gets there early. We all get there early because we know he'll start early. And as the jurors come in, he'll say good morning, or he may be walking. Sometimes he'll be walking down there, open up the door for him. I mean, he's putting them at ease constantly. Let's put it that way. It's the perfect place for a juror to come to court and serve.
And in this putting them at ease and being friendly, is he ever undignified?
Not in the least. I happen to be a big believer in as much informality as possible. Having spent so much time in federal court, I try to do the same thing with our federal judges because I'm friendly with quite a few of them, and I've had that discussion with them. Jurors are not comfortable when they come to court. And if you can make them comfortable, they can do a better job as jurors. They can go out and tell other people that you don't have to worry about jury service. It's not like going to prison for a month. And I just think it's a positive for our system.
Have you observed him interact with prosecutors and with defense attorneys?
Yes.
Have you observed him interact with women prosecutors and women attorneys?
Of course.
Has he ever been discourteous? Have you ever observed him be discourteous to any lawyer?
I've never seen him be discourteous to anybody.
Does he treat male and female counsel, including prosecutors, the same, or does he do anything different based on their gender?
I've never seen Judge Morrow do anything different, whether it's in court or out of court, that I thought in any way, shape, or form was different about how he treats females.
Have you ever heard him use sexually graphic, inappropriate language in court or out of court?
In court, for sure, no. I mean, I don't know about sexually graphic. We've certainly cursed plenty playing ball. But no, sexual language, I've never heard him use any.
Does his interaction with the jurors erode public confidence in the judiciary?
The opposite. It's absolutely the opposite.
Is there anything in his interaction with attorneys that would lead you to conclude that he erodes public confidence in the judiciary?
Absolutely not. Unless there's a lawyer who doesn't like to start on time, that'd be the only lawyer that'd have a gripe with him.
Have you ever attended a chambers conference with Judge Morrow?
I've attended chambers conferences with him about a case. Not all that often, quite frankly, but I've obviously been in his chambers any number of times because when I go in the building, particularly as I've had fewer cases over there, I stop to see him. We go in the back and, we shoot the bull, I guess, for lack of a better phrase.
Is his conduct different in chambers than it is in the courtroom? And is your conduct different in chambers than in the courtroom?
As far as I'm concerned, based on my experience, never can say everybody. Of course, conduct is different in chambers. Chambers is way more informal, and that's the case in 90% of the judges that I've been in front of and in chambers with, whether it's in state court or federal court. It's completely different, totally different. And judges often invite you in the back in chambers, including some of our federal judges, because they want to talk frankly without having it be on the record. Obviously, both sides are there. I mean, the prosecutor's there and the defense lawyer's there. But I think that the informality in chambers makes things a lot better for when you go back out and you're on the record and everybody's a little bit more formal.
If you were in chambers and you didn't wish to stay and the judge was talking, how would you extricate yourself from this situation?
I've had that happen a few times. I tell the judge I got to go. It's pretty simple. I don't know if everybody else does that, but that's always the way I handle it.
Mr. Fishman, what is the purpose of the rules of evidence?
The purpose of the rules of evidence is to assure that everybody has a fair trial and we all know what we can do and what we can't do.
Does it control what kind of evidence comes in?
As far as I'm concerned, of course it does, sure.
There's some evidence that should not be placed in front of the jury.
Yeah, like the entire lawsuit that Judge Stevens threw out that was a Trump's campaign and was all hearsay.
So there are instances where the evidence is more prejudicial than it is probative?
That's a separate rule, of course.
Are you familiar with Michigan Rule of Evidence 404B?
Yes.
Can you tell us what it is?
It's what every defense lawyer is always afraid of because it allows in what's now called other acts evidence. When I started, it was called similar acts evidence. And generally, not generally, 99 times out of 100, it doesn't help the defendant very much, that's for sure.
Does it have an effect on the presumption of innocence?
I don't know that it has an effect on, the judge is still going to instruct on the presumption of innocence, but there's not very many people, particularly jurors, that aren't going to look at the guy a little bit differently. For instance, if I'm trying a case where there's 404B evidence, I make sure the jurors know it in voir dire, because I'm a big believer in letting the jurors know all of the worst things. So if those jurors are going to say, well, he supposedly pulled something else, well, I can't presume him innocent. I can get rid of him.
So it's your conclusion that it would be harmful to the presumption of innocence?
I don't know if that's a hard question to answer. The rule, and then 403, which excludes it if it's more prejudicial than probative. I don't know what to say about it. It's harmful to the presumption of innocence. Makes it harder on the defense lawyer and the defendant. That I can tell you for sure.
Can you explain the procedure that a prosecutor would have to go through to get 404B evidence admissible? All
I can talk about is what's happened in my cases over 47 years. I think that that's representative of how it's supposed to be. I've never had a case ever that was a potential 404B case where the prosecutor did not notify me ahead of time. In addition to saying that they had 404B evidence, they would notify me as to how they intend to get it in. What witnesses is it going to be? Is it going to be exhibits? The reason for that obviously is I'm going to need to file a motion to keep it out. And at some point in time, the trial judge is going to have a hearing. And if I don't know, if the prosecutor just says, look, I have 404B evidence and I don't know what else, what they mean, what he or she is going to introduce, I'm going to be kind of standing without much to say to the judge. I need to know, and I always have known, what is it exactly that they're intending to introduce? And then we go from there.
Are you aware that in the case that is the subject of this investigation, that 404B evidence was going to be offered?
I do know that.
Objection, Your Honor. I think it might be hearsay unless he's reviewed the entire file and transcript and everything himself.
I certainly haven't reviewed the entire file. And I read the complaint and the answer because I was told I could read that.
Mr. Fishman, you need to wait. Ms. Jacobs, do you have a response to Ms. Wang?
I could go to another question and that might tie it up, Judge.
All right, so rephrase your question. Thank you.
Mr. Fishman, did you review the Michigan Court of Appeals order in this case from June 6, 2019?
I did. I saw.
Can we have slide 12, please?
Your Honor, if I could have 1 second while they're getting that file. Oh, my file was acting up a little bit. It's fine. It's resolved itself. I apologize.
All right, thank you. I think anytime we're ready to share the screen, you may.
Yes. We're just trying to get it, Judge. Here it is. No, I'm sorry. This is not. I'm sorry, Judge. We are having a problem finding the correct slide. It's the order, the Court of Appeals order that I. Exhibit F. Yeah, it's Exhibit F, but is this it? 19? No. Hold on, let me.
Lesbian has ever asked questions and we'll find it.
Is it Exhibit F? Let me find it. Please, yeah, thank you. Okay. I'm sorry, Judge, we have a lot of exhibits here. When is 404P evidence properly offered, Mr. Fishman?
Objection, Your Honor. That asks for a legal conclusion.
Judge, he is a lawyer for 44 years.
When I had that response to an objection yesterday, Your Honor sustained it.
Thank you, counsel. Objection is sustained.
We're just bringing up the order now. Did you have an opportunity to review this order?
I looked at it and I think I remember it. I don't know that I need to see it. I think I remember it.
Is there anything in that order that would allow the prosecution to offer 404B evidence in its rebuttal case?
Objection, Your Honor.
What's the objection?
They have not made him an expert witness, and even though he's a lawyer, I don't think he's allowed to comment on what a Court of Appeals ruling means.
Objection is sustained.
Can we make a separate record, Judge?
Yes. Ms.
Thank you.
Jorgensen, let us know when you're ready. You're muted right now.
Yes, thank you, Judge. And I'll read back the question, Judge.
Certainly, please.
Is there anything in this order that would allow the prosecution for 404B evidence in its rebuttal case?
Mr. Fishman, we're on a separate record. Can you answer that question?
My recollection of the order, I didn't see the word rebuttal mentioned. What the order said to me was that the prosecutor was to bring up the 404B issue when there was sufficient evidence for the judge to rule on it. It was an odd order I'd never seen one quite like that, to tell you the truth. But that's what it said to me, that at some point in time during the prosecution's case, if the prosecution so choose, they could bring up to the court. And now because of X, Y, and Z that we've just produced, we want to bring in the 404B evidence that you had denied back in the pretrial hearing. That's what I read it as.
I'd like to go back to the main record, Judge.
All right, let us know when you're ready, Ms. Jorgensen.
I'm ready. Thank you, Your Honor.
Proceed.
Is 404B evidence a rule of automatic admission?
Of course not. That's why you can challenge it.
Judge, again, I object to this line of questioning. He is not an expert witness.
Well, I would just answer to that he doesn't have to be an expert witness to answer this. This is common knowledge among attorneys.
I'm going to sustain the objection. Would you like to go on the separate record again?
No, Judge. No, that's fine.
Continue then.
Would it be, Mr. Fishman, does a judge have a responsibility to try to improve the quality of legal practice by attorneys who appear before them?
Objection, same objection. He's not an expert witness.
We asked it of Jeffrey Edison, and there was no objection then.
That's because I missed it.
Any further response, Ms. Jacobs, before I rule?
Oh, thank you. I think it's a fair rule. I think it's a fair question.
Objection is sustained.
Mr. Fishman, since you've taken, strike that. Can you tell us, if you know, what Judge Morrow's reputation for integrity is?
What I know from everybody I talk to, his reputation is excellent.
And what is your opinion of it?
I agree with his reputation that everybody else says.
What is Judge Morrow's reputation for how he treats litigants, counsel, jurors, and the public?
Reputation is excellent. I've never heard anybody, any lawyer, say that he doesn't treat everybody well.
Is he courteous? Does he have a reputation for being courteous?
Absolutely.
Does he have a reputation for being respectful to litigants, counsel, jurors, and the public?
Yes.
Does he treat litigants, counsel, jurors, and the public fairly?
Yes, he does.
What is Judge Morrow's reputation for how he conducts himself? Is he dignified? Is he proper?
I never really would use the word dignified. He's certainly proper. He's a little more informal than other judges. And there are other people like him who are more informal. There are people who are more formal. But in my view, that doesn't have anything to do with whether you're conducting yourself properly as a judge. As I said before, he makes people comfortable in the courtroom, including defendants who he sentences to probation and then has them come back and sit in the courtroom because he cares about them, what they do, and tries to get them on the right path. That's not something you see very often in judges' courtrooms.
Does he have a reputation as a judge who swears or uses sexually graphic language inappropriately?
I've never heard anybody say anything like that until I read the newspaper about this case.
And what is your opinion of that? Have you ever heard him swear or use sexually inappropriate graphic language?
In all honesty, I would say amongst our group, particularly going back all those years, Bruce is probably a person who swears less than any of us. In all honesty, I never really recall him sitting around talking the way some of us talk. And I'm not talking about in court, obviously, but whether we're playing ball or we were having dinner or whatever, he really is a lot. He just doesn't speak the way a lot of us do that grew up in the same neighborhood. Let's put it that way.
He have a reputation for treating female attorneys differently than he treats male attorneys.
Not at all. His wife is a female attorney, as you all know, and they've been together for some 30 years. And his wife's certainly nobody that would allow anybody to treat her poorly. That's for sure.
Does Judge Morrow have a reputation for harassing women?
Judge Morrow has no reputation for harassing anybody. And no, specifically, he does not have a reputation for harassing women.
And that is also your opinion?
Absolutely my opinion. If it weren't my opinion, I wouldn't be here testifying.
Thank you. Thank you. Your witness.
May proceed.
Good afternoon, Mr. Fishman.
Hi, Laura, how are you?
I'm well. How are you?
Stumbling along in my old age.
You look good. So would your opinion that Judge Morrow treats people respectfully changed if you knew that he asked two female APAs who he barely knew and were at least half his age what their height and weight was?
I'd have to know the context of it, honestly. I don't see that as something that's awful, but I don't know what the context was. When you take things out of context, it's impossible for me. It wouldn't change my opinion of him, but I'd like to know the context of how it supposedly happened and who was involved. And
why does it matter to you who was involved and what the context was?
because look, if we were going to sit and go through everything that any judge has ever said to people, or that people have said to the judge, I wouldn't want to tell you, or Judge Widgeon, the things that have been said to me by female judges when I was a younger man, obviously. I mean, it depends on context. When people say something to somebody else, it depends on the whole. Were they by themselves? Were they in chambers? Were they meaning it in a certain way? Did they have a certain look on their face? I mean, it's almost impossible for me to give an opinion on that, but I can tell you that I've been present and I've been the target of, if that's the right word, of people saying things, maybe not my height and weight, but talking about some other part of me.
So you told us that you've known Judge Morrow for years and he's been a judge for about 25 years. Would you agree?
It seemed like it was more than that, actually, but I don't remember. You know, when you get older, those kind of years start running together. It's been a while,
Okay.
That's for sure.
Well, let's assume for now that it's about 25 years and
Okay.
you've been in his courtroom many times. Is that fair to say?
Yeah, but not a ton of times though. Just I do stop in, and I always did, you know, just to say hello or something like that. But I haven't had all that many cases in front of him.
So you don't sit and watch him on a daily basis. Is that fair to say?
Yeah, of course. I don't watch any judge on a daily basis. That's true.
Okay. All right. Now, are you aware, you testified on direct exam that his reputation for integrity is excellent and that your opinion of his integrity is excellent. Is that
That's
fair
true.
to say? Are you aware that Judge Morrow has artwork all over his walls of his courtroom?
Of course. So did Judge Crockett.
And are you familiar with a picture on the wall of Bill Cosby?
No, I know it's what I would refer to as, he has a lot of Afrocentric. Is that the word we use these days? We would say in the old days that he had black art. I don't know if I've ever seen a picture of Bill Cosby. Really?
Okay. If there was a picture of Bill Cosby after his conviction for sexual assault.
Objection, speculation.
Response.
Well, we've had testimony that there was a picture of Bill Cosby after his conviction for sexual assault.
But
Ms. Bickerstaff testified to that yesterday.
I'm sorry, the disciplinary counsel is asking Mr. Fishman to speculate on if it was there. He didn't see it there.
Objection is overruled. You may continue.
Mr. Fishman, assume that Judge Morrow had a picture of Bill Cosby on his wall in the area where the prisoners sit, which is also near the door that witnesses go in and out of while they're waiting to testify. And it was on the wall after Mr. Cosby was convicted of sexual assault. Do you still believe that Judge Morrow has integrity in having that picture on his wall for the public to see?
Personally, if you're asking me, I probably would have taken Mr. Cosby's picture down, but I don't think it has anything to do with integrity with respect to the public. You know, I mean, you're saying it's over the prisoner box? Is that where it is?
Well, I don't want to tell you
Did
what
you
the
hear me?
testimony was yesterday.
No, I'm just saying, you said something about it's over by the wall or something like that. I don't know. I don't see how that has anything to do with integrity. I mean, I've never noticed a picture of Cosby before or after his problems, so.
You've also testified that Judge Morrow has the reputation for being courteous and respectful to people. Is that right?
That's true.
Did you also testify that that's your personal opinion also?
It's my personal opinion, it's my observation, and it's what I've heard from other people, yes.
Were you aware that Judge Morrow got himself in a bit of trouble through the Judicial Tenure Commission and through the State Court Administrator's Office in 2004 or 2005?
Is that when there was a hearing?
Well, the State Court Administrator's Office doesn't do hearings, do they?
I don't know anything about the State Court Administrator's Office or whatever. I was just asking, was this the last hearing?
Okay, no, the last hearing involving the Judicial Tenure Commission was in 2013.
Okay, so I don't know anything about what you just asked me, 2004 or 5, I don't know anything about that.
Okay, so I'm going to ask you a series of questions, and at the end of the questions, I'm going to ask you if any of this changes your opinion about whether Judge Morrow treats people, and women in particular, courteously or respectfully.
Okay.
Were you aware that on October 6th of 2004, the State Court Administrator's Office did an investigation and wrote Judge Morrow a letter where it accused him of engaging in, quote, inappropriate personal conversation with a personnel staff person, asking inappropriate questions and making inappropriate personal comments?
I don't know anything about that.
I'm
No.
sorry, we talked over each other. So let me start that again. Were you aware of that finding in that
No.
letter? Okay. I'm going to also ask
No.
you if you were aware that the State Court Administrative Office letter instructed Judge Morrow, quote, it is inappropriate to discuss matters of a personal nature with court staff unless that individual is an acquaintance or friend. Were you aware that the State Court Administrator's Office cautioned Judge Morrow about that?
No.
Were you aware that on April 5th of 2005, the Judicial Tenure Commission admonished Judge Morrow and told him in a letter, quote, similarly, the commission cautions you against engaging in conversations with court staff which are of a personal or intimate nature and which may be regarded as offensive or embarrassing.
I don't know anything about that. No.
Were you aware that in 2000 or 2001, Judge Morrow said to a clerk on the 9th floor at the Frank Murphy Hall of Justice, words to the effect of, do you have children? You should have more children. The best time to have sex is when you're menstruating. Did you know or hear that Judge Morrow said that to someone?
I've never heard that.
Do you know that in a transcript in the case of People versus Adrian White, case number 18-8430, on October 19th of 2018, Judge Morrow asked a hypothetical question in a non-sex related case, whether he would have an expectation of privacy if he were to have sex with another male in a restroom?
Run that one by me again.
That he asked a hypothetical question during a motion hearing in a non-sex related case about whether he would have an expectation of privacy if he were to have sex in a restroom with another man.
I've never heard that, but I have no idea what he's talking about there.
Okay. I'm going to ask you a few more questions. Do you know that in 2018 or 2019, he shared with a male and a female prosecutor that he shaved his armpits?
No, I didn't know that.
Do you know that he also, during that same time and same conversation, asked a female APA what color her armpit hair was?
No.
Now, if you had known all these things, does that change your opinion about whether Judge Morrow is courteous and respectful to women?
It doesn't change my opinion unless I know the context of all these conversations. It depends, to me at least, on what kind of relationship the judge has with the people he's talking to. And I've unfortunately had the experience, not myself, but have had other friends of mine who were judges where people said something that they shouldn't have said, and the judge said, I just need the context. Well, I can't answer those questions. It doesn't change my opinion based on my knowledge of him, my observation of him, my knowledge of his reputation, my knowledge of just him, of being around him for all these years. I've never seen anything anywhere near what you're suggesting, and I've never seen anything or heard anything from anybody else that causes me to change my opinion. And as I said earlier, if I really believed that he was a harasser and a sexual abuser of women, there's no way on earth, no matter how far we go back, no matter how many ball games we played, no matter how close I am with he and his wife, that I would testify on his behalf. So that's my answer.
All right. Now, you indicated that on at least one occasion you heard Judge Morrow educate the jury about bias and perceptions using basketball and height of you and Judge Morrow as an example, right?
Yes, just so it's clear. He used basketball and height and me as an example. I've heard him talk about bias every time there's a jury trial. Even if I happen to be in there waiting for something, that's one of the things he discusses.
Have you ever heard him teach a jury or voir dire a jury about bias and perception using anything sexual?
I have not, but you got to understand though, as you know, when I left the defender's office, I haven't had a sex case since. I don't take sex cases, so. But no, I have not.
Nothing further.
I have no further questions. Thank you.
I'm sorry, Ms. Jacobs, you said no additional questions?
I apologize. No additional questions.
All right, thank you. I just didn't hear you. May this witness be excused?
Yes.
Yes, please.
Thank you, Mr. Fishman. You are excused, and I will just remind you that you're still under the sequestration order until the termination of the proceedings.
Okay. Thank you, Judge.
Thank you.
Your Honor, may we call our next witness?
Yes, you may. Who is your next witness?
Detective Joanne Kenney, Kinney. Joanne is without any.
All right, one moment. Let me just ask, does anyone need a break before we have Detective Kenney come in from the waiting room?
I do not.
Ms. Jorgensen? All right, you're muted, but you'll.
I apologize. I do not need a break.
All right, thank you. I'm going to admit her at this time.
She shouldn't need any help. She should come right up the screen as soon as the master. That's.
Is she only going to be on audio?
No, sure. Should be on Zoom.
Mr. Campbell, is this one of the witnesses who is in one of the rooms next door and may have some difficulty with the audio or video?
Yes, Your Honor. I'm going to have my assistant Lori Hagan go into her room and check. We thought it would just appear on the screen and she would be all set.
All right, thank you.
She is in your waiting room, is that correct?
She was. I brought her in from the waiting room and I just see on the screen that she is connecting to audio.
Lori, are you able to hear us?
Yeah. Can you wave your hand a little bit and the camera will go to you?
Well, again, yeah, when she starts speaking, it'll focus.
All right, thank you. Good afternoon, Detective.
Good afternoon.
My name is Betty Widgeon. I am the master appointed by the Michigan Supreme Court to hear this proceeding. And we're going to start with me swearing you in. I'm going to give you the usual oath. That is, I heard someone in the waiting room, but that's the next witness, so we'll just leave that witness there. But yes, I would like for you to raise your right hand, and here is the oath. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, I do.
All right, thank you. Detective, there are also two orders that are associated with this proceeding, and the first one has to do with sequestration of witnesses. So I'm going to read that one to you first, and then there is a second one. Parts of this order. The amended sequestration order reads that this order will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. Sequestration prohibits any witness, except while testifying during the proceeding, from discussing his or her testimony in any format or by any means with another witness, from viewing the proceedings on any device, listening to the proceeding on any device, and accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to discovery of the failure or violation. The amended order regarding the hearing and witness protocol says, with respect to witnesses, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. I know that you are in one of the offices for Respondents Counsel, and I would like to ask at this time, is there anyone else in the room with you?
No, ma'am.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and texts, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you understand those orders?
Yes, ma'am.
All right, and Detective Kinney, do you swear or affirm that you have abided by those orders and that you will continue to abide by those orders unless and until you are released or the proceeding has been completed?
Yes, ma'am.
All right, thank you so much. I appreciate that. We are ready at this time, Mr. Campbell.
Thank you. Detective Kenny, have you testified before?
Yes, I have.
All right, we'll begin as we always do then. Could you please state your full name and spell your first and last name for the court reporter?
My name is Joanne Kinney, capital J-O, capital A-N-N. Last name Kinney, K-I-N-N-E-Y.
Detective Kinney, where are you currently employed?
Wayne County Prosecutor's Office.
And how long have you been employed there?
13 years.
Before that, where did you work?
Detroit Police Department.
And how long?
Homicide.
Thank you. How long were you employed there?
33 years.
I'd like to focus your attention on an investigation that occurred within the Wayne County Prosecutor's Office in June of 2019.
Yes.
Okay, thank you. Did you have occasion to do an interview of Anna Bickerstaff?
Yes.
Did you have an occasion to do an interview of Ashley Chiffone?
Yes.
Am I correct? Both of those ladies were assistant prosecutors at the prosecutor's office.
That's correct.
Am I correct that the only time in your career that you've taken a statement from those two ladies is in connection with the June 2019 investigation?
That's correct.
Who ordered or directed you to take a statement from those two?
My supervisor.
And can you tell the master who your supervisor was at that time?
Chief Bivens.
Am I correct if I refer to him as Chief Bivens?
Yes.
And did you review anything before you spoke to Anna Bickerstaff, if you remember?
No, sir.
When you spoke to Anna Bickerstaff, where did that conversation take place?
On the 12th floor in Chief Bivens' office.
And so the record is clear. That's the 12th floor of the Frank Murphy Hall of Justice, downtown Detroit, correct?
That's correct.
Is that also where your office is located?
Yes, about 3 doors down. Yes.
Thank you. When you spoke to Anna Bickerstaff, was anybody else present?
No one was present but me and her.
Thank you. Did you record that conversation electronically or digitally or in any other way?
No.
Did you keep notes or take notes during that conversation?
I took a written statement from Anna.
Did Anna write the statement out, or did you write information based on what she said?
I wrote the statement out.
At the conclusion of your writing of the statement, did you ever show that to Anna Bickerstaff?
Yes, I did. I gave the statement to her and asked her to review it to make sure what she said was correct in the statement. And I asked her to sign each page of the statement.
How many pages were there to the statement, if you know?
I think it was approximately 4 to 5 pages. I'm not sure.
And what did you do this on the very same day? In other words, the interview, and then you had her review, or were these two different dates?
The same day.
Part of the same interview, is that fair?
Same interview, yes.
And what did you do with your notes from that interview?
I didn't have any notes. I verbally listened to what she had to say, and then I asked her the circumstances. I wrote them down. Then I asked her a question and answer. I didn't take any notes. I just took the statement.
Thank you. What did Ms. Bickerstaff sign each page of that statement?
Yes, she did.
And what happened then to that document?
Once I completed both statements, I gave those statements to my supervisor.
And again, that is Chief Bivens, correct?
That's correct.
And you're aware that Chief Bivens made a memo to Prosecutor Worthy from, among other things, the materials that you provided, including the statement of Anna Bickerstaff, correct?
I was not aware of any report that he made.
You say you were not aware. When did you become aware?
I became aware when I talked to you and Ms. Weingart about the report.
In the state, do you remember what Anna Bickerstaff said to you in that interview?
Yes, she told me what happened, and she informed me that she asked Judge Morrow for some pointers. He came off the bench,
Objection to
came
the
down
hearsay.
to,
Objection, Your Honor, it's hearsay.
It's not offered for the truth of the matter asserted. It's offered for impeachment of Anna Bickerstaff's testimony in this proceeding.
Then I think he has to ask her the question that is impeachment, not a general overview of what Ms. Bickerstaff told her.
Mr.
I'm
Campbell,
ready to do that if you would like. I didn't want to cut off the witness.
yes, if you would, Mr. Campbell, just ask the questions individually.
Thank you. Did Anna Bickerstaff tell you, give me a moment here. I have to find it, sorry. Did Anna Bickerstaff tell you that she felt Judge Morrow was trying to hit on her because of what he stated regarding sex and foreplay?
I don't remember that.
Do not remember that being part of a statement that you took?
I don't, only thing I remember when I asked Anna, what did you think he was trying to do? And her answer was, I know what he was trying to do, but as far as him hitting on her, I'm not sure about that.
I'd like to show you Chief Bivens's memo to see if that refreshes your memory when you say you're not sure about that. So I'd like to do that. You're a room away from me. I have a copy of what's been marked as Exhibit 12 to these proceedings. With the master's permission, I would show that to you.
Judge, I object. I don't think she has said she doesn't remember what Ms. Bickerstaff told her, such that she should have her memory refreshed with Mr. Bivens' report.
Judge, you could ask the court reporter to replay it, or maybe you remember it as I do. She said that she didn't remember. This is how recollection is refreshed. Ms. Kinney, is that your cell phone? No? Maybe it's the master's line.
No.
I don't know where that sound came from.
No, it was not my line. Ms. Kinney, you don't have a cell phone or any kind of alarm in the room where you are? And I'll have to ask you to unmute again because you are muted right now.
Well, I'm going to ask my assistant to also help with that. Go ahead. Let's wait for Ruth.
Can you hear us?
Yes.
All right, counsel, I would like to take a 5-minute break and have a sidebar with you. And I will have a breakout room. Miss Detective Kinney, if you would remain where you are, please.
Yes.
you hearing anything that's going on right now? Okay. Thank you. The judge was just concerned about the cell phone being on, and you have turned it off, and it can remain off for the rest of the, okay, thank you. That's all she wanted to know.
I believe we are ready to proceed.
All right, thank you. You may continue.
Thank you. I believe
I'm
we are.
sorry.
Yeah.
Remind me, Ms. Jorgensen, where we were. Was there a question that I needed to resolve?
One moment. It was over an objection about refreshing recollection.
Yes, would you please read the questions before and the answer right before the objection?
Yes, I will. The question was, you do not remember that being part of the statement? The answer was, I don't. Only thing I remember when I asked Anna, what did you think he was trying to do? And her answer was, I know what he was trying to do, but as far as him hitting on her, I'm not sure about that.
All right, so counsel, it appears that we have two statements that were talked about. We've got the statement of Anna Bickerstaff, and then we have, I believe, the report for, is it Chief Bivens?
It's Chief Bivens's report that contains statements attributed to Detective Kinney. And I would like to show Detective Kinney the portions that are attributed to her within Chief Bivens's report to see if that refreshes her recollection as to the interview with Anna Bickerstaff.
Ms. Weingarten, your response was?
Judge, I think she testified that she only remembered Ms. Bickerstaff saying, I know what he was trying to do. And she doesn't believe she said, I'm hitting on her. And to refresh her recollection with something that a third party wrote, I don't think it's proper refreshing of recollection.
All right, I'm
Yeah,
going.
If I may, in response to that, unless, okay, I'll let you rule, but I may have further argument.
I'm going to sustain the objection, and if you would like to make a separate record, then we can do that at this point.
I'd first like a reconsideration. Judge, you can refresh anybody's recollection with anything, as long as it refreshes their recollection. In fact, that same dialogue took place in the criminal trial of James Matthews. I think that was one of the screens that I showed Ashley Chiffone, the fact that you could use anything to refresh recollection. So that's, Ms. Weingarten's wrong about that. I think hopefully she'd acknowledge that she's wrong about that. Secondly, Judge, if the full statement was, that's what I can remember, I'm not sure about the rest. How much clearer can you have as a statement that there's something out there that can refresh your recollection? It's not a no, like it was in the Matthews trial. Judge, this is very, I think, direct, and that's why I am asking for the reconsideration. This is refreshing recollection.
Thank you, Mr. Campbell. So the objection is sustained. If you would like to make a separate record, we will do that right now. And I will ask the court reporter if you would please read that again and put us on a separate record. Thank you.
I will, just a moment, Your Honor.
Here's a copy. I'm going to ask you questions about it, okay?
Question was, you do not remember that being part of the statement. Answer, I don't. Only thing I remember when I asked Anna, what did you think he was trying to do? And her answer was, I know what he was trying to do, but as far as him hitting on her, I'm not sure about that.
All right, Mr. Campbell, go ahead, please.
Thank you. Detective Kinney, you have now before you what has been marked in these proceedings as JTC's Exhibit 12, and that is a memorandum, as you'll see on the front page, dated July 8th, 2019. Can you see that?
Yes.
And it bears on the 2 line, Kim Elworthy. You know who Kim Elworthy is, right?
Yes, yes, I do. She's the prosecutor, yes.
And it's from Jay Bivens. Do you see that?
Yes.
That's Chief Bivens, correct?
That's correct.
There's a subject line on that first page that refers to the investigation that this memo is regarding. That is, in fact, the investigation that you helped conduct when you interviewed Anna Bickerstaff, correct?
That's correct.
I want you to go to page 3 of the document. Are you there?
Yes.
And it says, on Monday, June 17, 2019. Do you see that?
Yes.
You go, there's a paragraph that begins, Detective Joanne Kinney interviewed APA Anna Bickerstaff. Do you see that?
Yes.
That's you. You're the only Joanne Kinney who was a detective with the Wayne County Prosecutor's Office in 2019, correct?
That's correct.
And Anna Bickerstaff is the APA that we've talked about at the Wayne County Prosecutor's Office, correct?
That's correct.
I want you to follow to the second sentence in that paragraph. Begins with the word she on the far right-hand side of the margin. Do you see that where it says she added?
Yes.
I want you to read that sentence until the period that you reach. I'm sorry, can you read it aloud?
She added that she felt Judge Morrow was trying to hit on her because of what he stated regarding the sex and the foreplay.
The she that is being referred to there is Ms. Bickerstaff, correct?
That's correct.
This is attributed to you by Chief Bivens, correct?
That from what it reads, but that's not what was in my statement.
You're sure, as you sit here, that was not in your statement?
No.
When's the last time you saw your statement?
When I gave it to Chief Bivens was the last time I saw it.
Is there any reason, take a moment here. Is there any reason why Ashley Chiffon, sorry, let me restate my question. Is there any reason why Anna Bickerstaff would be intimidated by you?
Objection,
No.
speculation.
It's not speculation, it's following up again, it's impeachment. Ashley Chiffon testified at page 313 of the transcript. Quote, I believe she, referring to Anna, found Joanne Kinney to be slightly intimidating. I don't know if you know investigator or Detective Joanne Kinney. She's a very serious woman. She's an older woman. And so I think Anna was nervous just because she is a little bit intimidating. I would say if I had to guess why Anna might have been nervous, to tell her. So that's not speculation, Judge. As counsel argued in her last round on the objection, we have the witness testimony. I can impeach Anna and Ashley on this concept that they were too intimidated by Detective Kinney.
All right. So one thing that is happening is that we're in the separate record. And
No, I apologize, but I thought we went to the full record.
No.
Okay. Then with that, I would like to go to the full record and ask my last question again.
All right.
I remember.
We're going to go to the full record, and then Ms. Weingarten, if you have that objection, you may make it and I will rule on it, but in the full record. Let us know when, Ms. Jorgensen.
We're in the regular record.
Thank you.
Thank you.
Do you need to have that question read again, Mr. Campbell?
No, I believe I know the line of questions and I know where I'll start on the full record, if I may.
All right, you may.
Thank you. When is the last time that you saw your statement that you took from Anna Bickerstaff?
The day that I took the statement, I gave those statements to Chief Bivens.
Is there any doubt in your mind that you gave those statements to Chief Bivens?
I gave those statements to Chief Bivens.
I want to make sure
There's no doubt in my mind I did give those two statements to the chief.
And you understood those statements would be used in order to make a report to Prosecutor Worthy, correct?
I know. I didn't know. He informed me he was going to interview the attorney that was present. And I gave the statements to him.
Thank you. Did you learn that in fact there was a memo that was made to Kim Worthy?
Yes, when I talked to you and Ms. Weingarten.
Thank you. Is there any reason why Anna Bickerstaff would feel intimidated by you?
Objection, speculation. How does this witness know how someone else feels about her?
Objections overruled. Continue.
Do you remember the question, Detective Kinney, or would you like it reread?
No, if I felt she was comfortable with me and I was comfortable with her, it was no intimidation. She spoke freely and she was emotional and she was upset, but I didn't feel that I intimidated her in any way.
Did Anna Bickerstaff ever tell you that you had a mistake in any of the information that you took down concerning her statement?
No, sir, I have not spoke with Anna since the day I took her statement.
Thank you. Give me one moment. That's all the questions that I have for this witness, Your Honor. Thank you, Detective.
You're welcome.
Thank you. Just a moment. Cross-examination.
Detective Kinney, do you know what date it was that you interviewed Ms. Bickerstaff?
I don't remember the date. I don't have nothing other than this report he just gave me, but I don't remember the date. I do not remember the date.
When you took the statement, did it have a date on it?
I put a date on it, yes, when I took it, yes.
Where is the 4 or 5 page statement that you took from Ms. Bickerstaff?
I gave the statements to Chief Bivens.
Did you retain a copy for yourself?
No, I did not, because I assumed he was going to give them back to me after he read them.
Did he give them back to you after he read them?
No, ma'am.
In the last week or so, have you tried to find those statements?
Yes, ma'am. I checked, went to the office, and I checked my desk. I checked my folders, and my mind, I remember giving my folder to him with those statements. Normally, he returns them back to me once he's finished with them, after he read them. But in this case, those reports were not returned back to me.
Did you communicate with Chief Bivens within the last week or so about these missing statements?
Yes, I did.
And did you ask him to look for them?
I asked him, did he have the statements? He texted me and said, I do. Then he called me at another date and time and said he couldn't find them. And he said, I found my notes, but I didn't find your statements. And I told him I would go back to the office, recheck my desk again, which I did.
And have you come up with that statement?
No, ma'am.
Okay. Now, when you were interviewing Ms. Bickerstaff, you indicated that she got emotional.
Yes, she was highly upset about what happened.
Object at this time. This is hearsay.
Response?
Counsel brought out on direct exam that Ms. Bickerstaff was emotional and upset. So I'm
Actually, it's the witness who testified. I didn't bring that out, but it is hearsay now to go into it as to anything specific to that.
I'm allowed to ask how Ms. Bickerstaff was acting when the interview happened, especially in light of the fact that Mr. Campbell brought out that she was emotional and upset.
Again, Mr. Campbell did bring it out. It was the witness that testified to it in a non-responsive way to the question. But separate from that, to the extent that she's going to elicit any statements, that would be hearsay.
I'm not asking for statements, Judge. I'm asking for her demeanor.
At this point, I am going to overrule the objection. If there is another objection, then I will rule on that. Continue.
Detective Kinney, can you tell me how Ms. Bickerstaff was acting while she was talking and being interviewed by you?
She was emotionally upset and she was nervous.
Okay, so what was it about her behavior that led you to the conclusion that she was emotionally upset?
She would teary-eyed as she spoke about what happened.
And what was it about her behavior that led you to believe she was nervous?
She was like nervous about the incident that occurred. She wasn't nervous talking to me. She was nervous because of what happened. And I guess to talk about it, she was emotionally upset.
Did she appear to be putting on an act?
No.
And you've been a police officer for 33 years before your job at the Wayne County Prosecutor's Office?
Yes, ma'am.
You think you're a pretty good, can you do a good assessment of whether someone is acting or not?
Yes, ma'am.
So when you turned over the interview of Ms. Bickerstaff to Mr. Bivens, were you aware of for what reason you had to take the statement in the first place?
Because of the investigation. He was head of the investigation and he asked me to take the statements from Anna and Ashley, which I did.
Did you know at that point what was going to be done with the interviews that you, besides giving it to Mr. Bivens, what it would be used for?
No, he did not discuss that with me. Only thing he advised me that he was gonna talk to the attorney that was present when the incident occurred. That's the only information that he shared with me.
So you're aware now that he has since written a 9-page report, a memo to Kim Worthy, is that correct?
That's correct.
Before your before you attended Zoom court today, had you seen a copy of that 9-page memo?
No, ma'am, this is the first I saw it.
The information that's in it, is it written by Mr. Bivens?
Yes, it's his words.
And do some of his words say that he's taking information you gained from some of the witnesses?
From what I'm seeing, it's not, these are his words. I don't think these are my words.
Okay, fair enough to say that he didn't do a very good job summarizing your interview with Ms. Bickerstaff?
I think he interprets some of the things that I've written in the statement.
He interpreted it in his own way?
Yes, his own words. He took my words and changed it to his words, put it that way, or her words into his words.
Okay. You also took a statement from Ms. Chiffon, is that correct?
That's correct.
When you interviewed her, were the two of you alone?
Yes.
Do you know if that was the same day or a different day than when you interviewed Ms. Bickerstaff?
I interviewed Ashley in the morning and I interviewed Anna in the afternoon hours, yeah.
Was Ms. Chiffon emotional?
Yes, she was. She cried.
Were you doing anything to make her cry?
No, she was crying while she was telling me what happened.
Did you believe she was putting on an act?
No, ma'am.
And that's based on your over 33 years in police work?
Yes, ma'am.
Were you able to find any writings that you made of your interview with Ashley?
I could not find Ashley's statement and Anna's statement was together, and I gave both of those statements to Chief Bivens.
And was Chief Bivens able to find Miss Ashley Chiffon's statement when you asked him to look for it?
No, he could not find either statement. It's probably misplaced somewhere. This happened in 2019, so this could be anywhere. But I know it's not on my desk because I keep tabs of my stuff. The stuff that I hold on to, I keep good records.
Okay, thank you. I have no other questions.
Mr. Campbell?
Yes, Detective Kinney, in your 33 years of police work, you were able to observe lots of people be nervous, correct?
Oh, yes.
You were able to observe lots of people cry.
Yes.
Right?
Yes.
People cry because they're concerned about their employment, correct?
People cry about everything, yes.
They'll cry because they're being interviewed by a detective.
Oh, well, I'm a familiar face around it, and I have not threatened anybody. I don't think she was crying because of me, because she comes to give me work, give me stuff to do. So no, I don't think that was the reason why.
Ms. Kinney, Detective Kinney, detective for 33 years with the police department, or a police officer for 33 years, correct?
Yes.
You've been with the prosecutor's office, was it 13 years that you said?
Yes, 13 years.
And you didn't know that Ashley Chiffon thought you were intimidating, right?
No, she was a friendly young girl and she was upset.
Fair to say, given Ashley Chiffon's testimony here, you missed that, right?
I missed what?
You missed that she felt that you were intimidating.
Well, she didn't give me that impression. Maybe that's what she's telling you, but she didn't give me the impression. I know Ashley. I see her every other day or when she's around. We talk, we communicate. I never had any incident with her. We were good together. I mean, we talked all the time. Laugh, joke. Yeah. And I didn't see me being intimidating towards her.
Fair to say that Ashley Chiffon was able to hide from you the fact that she feels that you're intimidating.
She didn't appear to be that she was hiding anything from me. She was crying, she was upset, and then afterwards she was fine. When she was telling the story, she was emotionally upset. But no, I never intimidated her. And only thing I did, asked her what happened. I asked her some questions. She gave me the answers, and it was very simple.
So when Ms. Chiffone testifies that you were intimidating, do you think she was lying, or do you think that you misjudged her?
I think she was being.
Wait, I object.
What's the objection?
I believe counsel is mischaracterizing the testimony. I think Ms. Chiffone testified that she believes Ms. Bickerstaff felt intimidated, not that she felt intimidated.
Mr. Campbell, in response? Yes.
Yeah, page 313, it's that she is intimidating. She's a very serious woman. She's an older woman, and I think Anna was nervous. So she talks about Anna's nervousness, but it's the intimidation factor of Detective Kinney that's being referred to. And this was all opened on the cross-examination about 33 years and her ability to perceive. I think it's a fair question.
So to the objection of mischaracterization, the objection is sustained. If you would like to ask the question to reflect the actual person, you certainly may do that.
Thank you. Did you perceive that Anna Bickerstaff felt that you were intimidating?
No, sir.
Do you think that Anna Bickerstaff, well, who knows Anna Bickerstaff better, you or Ashley Chiffone?
When I interviewed Anna, that was the first time I met her. So Ashley knows Anna better than me. I have seen her around the office, but I have never had any communications with Anna, other than the day that I took her statement.
Thank you. I have no further questions for this witness.
You, Ms. Weingarten, anything further?
Yes, please. Detective Kenny, you said someone gives you work to do. Who were you referring to?
My bosses, Chief Bivens and Deputy Chief Brian White.
Do you ever get work assigned to you from APAs?
Yes.
Has Miss Ashley Chiffone ever given you work to do?
Of course, yes. I have looked for witnesses for her. I have served subpoenas for her. I have done liens for her. Whatever she needs done, she has come and asked me, and I have been more than willing to assist her.
And did that occur, all that work you just described, did that occur before the June interview?
Before and after.
Okay. And you said you had really no relationship with Miss Bickerstaff except for your interview with her.
That's correct. She was new. I really didn't get to really know her, and I really didn't do too much work for her.
What about after your interview with Miss Bickerstaff? Did you become more acquainted with her after that?
Yes, I would see her in the hallway, in the office. We'll smile, hi, how you doing? That's it.
Thank you. I have no other questions.
Okay.
I have a couple based on that, if I may.
Yes, go ahead, Mr. Campbell.
Thank you. How many times would you see Ms. Bickerstaff over the last 15 months?
A lot of times, about maybe 20 times, 20 or 30 times.
Did she ever say to you that there was an error in your report to Chief Bivens?
No, we never even talked about the case anymore after that. Never. That was the first and the last time we talked about that incident. That incident has not come up since I took that statement.
Again, you didn't know that there was a statement in the Bivens report that Ms. Bickerstaff says was wrong until these proceedings.
No, I didn't. No, I did not.
I want you to assume that Ms. Bickerstaff has known that since July of 2019 that there was a false statement in the report and that it was attributed to her by you?
No, I did not know. And I asked Anna to read her statement. Because sometimes when you write statements, you write a little faster than what they say or a little more than what they say. I asked her to review her report. I asked her to make sure what I wrote down is what she said. And then I asked her to sign it.
Did she read it in your presence?
Yes, she did.
Were you convinced that she understood it in your presence and then signed it?
And what was in my statement that I wrote was true in what she told me, what I wrote. Now, I can't speak for somebody else's writing, but what I wrote, she did read it and she did agree and sign that it was correct.
At any time, let me ask you this, isn't it true that all the times that you've seen Ms. Bickerstaff since July of 2019, there was an opportunity for her to say to you, Detective Kinney, there was an error in that memo that Chief Bivens wrote, but she did not say that to you, but she had the opportunity, right?
Anna did not mention anything else about that incident since the day I took her statement. That incident was never discussed again. It was done.
But Detective Kinney, I want to make it clear. It was only done because Anna Bickerstaff did not bring it up, right? She had
it was done because I took the statement and I had nothing else. I handed it over to Chief Bivens. I had nothing else to do with the case. I did not ask any more questions, and I did not know her statement was not true or what was in her statement was not true. I did not know any of that until today.
Chief Bivens, I'm sorry. Detective Kinney, please look at page 3 again. Look at that sentence.
Like I said, that I don't remember. I don't even remember that contents in my statement. I don't remember it. I don't remember. I remember her saying, I said, what was he trying to do? And she said to me, I know what he was trying to do. And that was it.
Detective,
the word is not my wording. It's not my statement.
Detective, you really got to let me ask the question before you give the answer.
Okay.
And the question is this. There's nothing that would have prevented Anna Bickerstaff from talking to you about what she read in Chief Bivens' memo from July of 2019 to today, right?
No, she never mentioned anything like I explained. She never said anything about that case to me. And I have seen her over 30 times over the year. And I have not, she has not said anything to me. No, she has not said anything to me.
But you're still, she had the chance.
I did not write this report, James. The Chief Bivens wrote this report. I did not write the report. I wrote a statement that I took from her. And she read that statement and she signed that statement. And if it was something in that statement that was not true, she had the opportunity to say, Detective Kinney, this is not what I said. And I would have corrected it.
Thank you. Not only did she have that opportunity when you had her sign it, but all the time since, she's had the same opportunities over 30 times and never said anything to you, correct?
No, she did not.
Thank you. I have no further questions for the witness. Thank you.
Ms. Weingarten, you get the final opportunity if you have any other questions.
No questions, thank you.
May this witness be excused.
Yes.
Yes.
Thank you, Detective Kinney. We will excuse you. Remember, you are still under the sequestration for witnesses order. Thank you so much.
Thank you, ma'am.
You're welcome.
You're welcome.
Your Honor?
Yes.
We have obviously some technical issues to take care of on our end, closing the other owl where the witness testified. We have our next witness, I believe, in the room, which is Mr. Noakes. I wanted to talk about scheduling and ask if this is an appropriate time to take a 10-minute break and then come back. And it's our expectation that Mr. Noakes will take the rest of the afternoon, and the remainder and balance of our witnesses would begin on the next day of the hearing that we've already set, which is December 7th.
Right, I see that Mr. Noakes is in the waiting room, and it looks like Detective Penny is there also at this time. So you want a 10-minute break at this time? It's 3:20. We will come back at 3:30. Thank you.
Thank you.
Thank you.
Okay.
Let me close this, hold on.
You're still live till I mute.
sorry, what did you say?
Are we ready to begin?
I am.
Yes, Judge, we're ready.
All right, thank you.
And our next witness is William Noakes. He's in the waiting room.
All right, I will bring him in.
Thank you.
Good afternoon.
Good afternoon, Mr. Noakes.
That's correct.
I'm Betty Widgeon. I am the master appointed by the Michigan Supreme Court to hear this proceeding, and we will start with me swearing you in.
Can you give me just about 30 seconds? You caught me in the middle of making some coffee.
I can give you 30 seconds for sure.
Thank you.
Don, you brought out that they mentioned height during jury voir dire, right? I don't have to bring that out again.
All right, I'm present and ready to be sworn in.
All right, thank you. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Thank you, and please spell your name. State your name first and then spell your first and last name.
William Noakes. It's spelled William. Last name N as in Nancy, Oakes.
All right, thank you. There are two orders. One is the sequestration order and the other one has to do with witness protocol. And I'm going to go over that information with you. And when I am done with it, I'm going to ask you if you swear or affirm that you have abided by these orders and that you will continue to unless you are, and until you are released from this order by the master or the proceeding has concluded, the final witnesses, evidence, and all of that. So starting with the amended sequestration order, this order will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. Sequestration includes, it prohibits any witness except while testifying during the proceedings from discussing her or his testimony in any format or by any means with another witness, from viewing the proceedings on any device, from listening to the proceedings on any device, and accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to the discovery of the failure or violation. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Mr. Noakes, are you alone in the room where you're testifying?
Yes, I am.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, laptops, iPads, smartwatches, or similar devices during their examination. So you've heard those orders. Do you swear or affirm that you have abided by those orders and that you will abide by those orders unless and until released by the master or the conclusion of the proceedings?
I do so swear.
All right, thank you, Mr. Noakes. You may begin, Ms. Jacobs.
Thank you. Good afternoon, Mr. Noakes.
Good afternoon.
We've not met in real life, have we? We've only talked on the phone?
That's correct.
Will you please tell us if you were the defense counsel in case number 18-007023, People versus James Matthews?
I don't recall the specific number, but I certainly was the defense counsel for Mr. James Matthews in a case before Judge Bruce Morrow.
Thank you. Before we turn to discussing that case, can you give us a little background? And I know that your CV is long. Can you do the highlights for us?
Sure, I'll give you the highlights.
When were you admitted to the bar?
I was first admitted to the bar in the state of Illinois in 1983. I later was admitted in Michigan in 1989.
And what was your first job as a lawyer?
My first job as an attorney was with the Department of the Air Force. I was a captain in the Air Force and a judge advocate.
How long did you do that?
5 years.
Now I'm going to turn it over to you. Or maybe I'm going to ask, did you work for the Securities and Exchange Commission?
Yes, after I left the Air Force, I worked for the Securities and Exchange Commission in the Division of Enforcement in Washington, D.C. for approximately 9 months before moving to Detroit to go to work for the General Motors legal staff. After that, I left and joined a firm in Troy, Kemp Klein, where I was a partner for the next 3 years. And in 1995, I became the Deputy Corporation Counsel for Wayne County. After 2 years there.
At Wayne County, who did you work under?
At Wayne County, the county executive was Ed McNamara. The deputy county executive was Mike Duggan, and the corporation counsel was Jennifer Granholm.
Thank you. Please continue.
After 2 years there, I left to become the general counsel of Wesley International, which was a $200 million minority-owned auto supplier. After those 2 years, I moved to Washington, where I had been asked to become the senior associate independent counsel in the trial of U.S. Secretary of Agriculture Mike Espy. After that, I came back to Detroit, where I was a partner in Jaffe Rate. And then in the summer of 1999, I was asked to become the general counsel of the Meyer Corporation, which I did for the next 9 years. Since that time, I've taught at the University of Chicago Law School, Southern Methodist University's Business School, Grand Valley State's Business School, University of Michigan Dearborn, and I've also been the director of government affairs for a company called Severstal, which is now known as AK Steel. And for the last 2 years, I've been a public defender.
What is the name of the office that you work for?
The office I work for now is known as the Neighborhood Defender Service of Detroit.
Are you also a Baptist minister?
Yes, ma'am. I most certainly am. I forgot to mention that in the year 2013, while I was teaching at SMU, I also attended the SMU Department of Theology, where I completed 60% of the requirements for the Master's in Divinity.
Is there a church that you officiate at?
Yes, I'm a licensed minister at the at Greater Christ Baptist Church in Detroit, under the leadership of Senior Pastor Perkins.
Directing your attention to the Defender Office, can you tell us the nature of your practice? For instance, is it all criminal?
It's entirely criminal defense.
What courts do you go to?
Most of the district courts in the county of Wayne, but primarily my practice is in the 36th District Court in Detroit and Wayne County Circuit Court.
In that capacity, have you had the opportunity to appear before Judge Morrow before the James Matthews case?
Most certainly. I had a number of cases before him, but the Matthews case was the first one that reached trial.
Thank you. So turning to that trial, before trial, did either Ashley Chavone or Anna Bickerstaff tell you that Emery Matthews was going to deny that his brother made admissions to him?
No.
And that testimony constituted 404B evidence, is that correct?
Well, not exactly. It could have constituted 404B evidence, but leading up to the case, there was specific 404B evidence that they wanted admitted, and that evidence was denied. So his testimony, it could be construed as 404B evidence, but it was not sought to be admitted as 404B evidence.
Did he make it? Did Emery Matthews give a statement to the police that his brother had committed more than one murder?
Well, his testimony, the statement really was that he had overheard his brother, Mr. Matthews, saying that and making comments to that effect. So that was the gist of his statement.
Was it your understanding that the prosecutors were going to offer that admission as evidence of a 404B crime?
Yes.
I'm sorry, one moment, please. I said 404B crime.
That's not 404, that's other acts.
It's the same thing.
Okay. Sorry, hold on a second.
To your knowledge, did the prosecutor have any other witnesses to that 1999 murder? And again, that's the 404B Act.
No.
Do you recall Judge Morrow's voir dire?
Yes.
Were you allowed to voir dire the jurors?
Yes.
Do you recall Judge Morrow cautioning you because you were asking a compound question?
Yes.
Did you think that was improper for him to object to your compound question?
No.
Did you take it personally?
I've been practicing for almost 40 years. I don't take things like that personally.
Also, during that first day, and that was on the first day of trial, correct? Jury
Yes.
selection. And then you swung into openings, correct?
Yes.
And Lester Masterson was the only witness of the first day.
That's correct.
During the opening argument, strike that. Did you review the trial transcript?
Yes, I did.
do you recall in the opening argument where Ashley Chavone made an argument in which she referred to red herrings?
Yes.
Do you recall the judge interrupting and say, "I love you for that," and then telling her that she couldn't proceed with that argument?
Yes.
Did you think there was anything improper in the "I love you for that" statement?
I didn't think anything was improper in that, but you also have to understand my background. I'm a man from the South. My family's from Virginia. I was raised in the South and around the country. And when somebody says, "I love you," it doesn't necessarily mean they love you. It's just a way of being. I mean, so I didn't take any offense at it, and I didn't see anything improper in it.
Thank you. Also, during that opening argument, strike that, during the testimony of Masterson, do you remember Ashley Chavone trying to refresh recollection and she was doing it improperly, so the judge stopped her?
Yes, I do remember that.
So by the end of the first day, you had been cautioned once and Ashley Chavone had been cautioned, or corrected, I should use that word, corrected twice. Is that right?
That's correct.
Ashley Chavone wasn't the only person then that was being corrected during this trial, correct?
No, I was told to do something different based on what I had done. And the judge said, you ought to do this differently.
Was there anything improper in Judge Morrow's handling of either of these three errors?
No.
Was he courteous when he made his statements to both of you attorneys?
Yes.
Was he professional?
Yes.
And do you think at the end of this first day of trial, he had treated both sides fairly?
Yes.
Do you remember Camille Leakes?
Yes, I do.
Can you tell us who she was?
Camille Leak was a witness who purported to be either an associate or a friend of Marcella Robinson, the victim in this particular case.
Okay. Did there come a time at which you asked this witness, Camille Leakes, to tell us, you used the phrase, tell us what your T-shirt said? Do you recall that?
Yes, I did. Oh, yes, I did.
And can you tell us what the T-shirt said?
I don't remember, but it was something that was obscene. And I just thought it was inappropriate to wear in the courtroom. So I wanted to highlight that for the members of the jury. And of course, Judge Morrow intervened and told me that that was not something I should do.
Do you remember your conversation with me, I want to say within the last week, in which you said the T-shirt said, "I don't give a fuck"?
I believe that's what it said.
After this first witness, did Judge Morrow become frustrated with both you and Ms. Chavone?
I don't think so. I just think basically what I'm looking at is the judge is looking at how can I move this trial along in the most effective, efficient way and keep counsel on track to ask questions in a proper manner, make objections that are proper, and not to stray from the rules of evidence.
Did he caution both of you to remain focused?
Yes.
The next witness was, I want to say, Jennifer Dillon. And during her testimony, you objected twice. Do you remember what happened to your objections, whether they were sustained or overruled?
I believe one was sustained, and I think the other one might have been overruled, but I know one of them was sustained.
Did you take that personally?
No.
Did you think the judge acted properly, even though
Yes.
you disagreed with him? Did you think he acted properly?
Yes.
The second from last, I want to say the second from last witness of the day was Dr. Galita. Can you tell us who
Yes.
Dr. Galita was? was Dr. Galita?
Dr. Galita he worked in the medical examiner's office at the time of the autopsy of Ms. Robinson.
After Dr. Galita testified, was there a break in the action?
I believe so.
During this break, where did you go, if any place?
If I remember correctly, I think we had, I think I may have headed to the lawyer's lounge after that.
If I reminded you that it was a 5-minute break, would you think you went to the lawyer's lounge?
Oh, if it's a 5-minute break, I probably only went to the restroom and came back.
Was your client a jailer or someone on bail?
My client, I don't use the term jailer. I find that derogatory. My client was in custody in the Wayne County Jail.
During the trial, during the days of trial, was he in the jail?
No, he was confined in the in a cell behind the courthouse.
Behind the courthouse or the courtroom?
I mean, behind the courtroom.
So if you had to visit him, how long would it take you to get to that lockup and then get back to your table?
If I went to visit him, it might take 30 seconds to get back there. And if I wanted to go back to the courtroom, it'd take another 30 seconds to get back to the courtroom.
When you came back from after this 5-minute break, did you observe any difference in the demeanor of Anna Bickerstaff?
No.
Did you observe any difference in the demeanor of Ashley Chavone?
No.
When you came back from that break, where was Judge Morrow?
If I remember correctly, the judge was seated on the railing by the jury box, which he normally, a lot of the time when I've been in his courtroom, he'd go over there and sit, even as he talked to people in the courtroom.
He would sit on the jury railing? The jury
railing, that's correct.
You put your client on that afternoon, is that correct?
Yes.
The afternoon of the second day. During the cross-examination of your client by Ashley Chavone, did the judge interrupt her?
Yes.
Do you remember why he interrupted her?
I believe it was because it was an improper question.
Did this have to do with Mr. Matthews sitting in court and listening to the witnesses?
Yes, it did pertain to that specifically. In fact, when we're talking about that, she objected, and the judge made very clear that he's the defendant. He's entitled to be in court during the entirety of the proceedings, and so he overruled her objection, or basically he overruled her asking him, essentially, did you learn something from sitting in court, implying that he was doing something that he was not permitted to do. And frankly, that's an issue that comes up frequently, and it bugs the heck out of me because the officer in charge is allowed to sit in the courtroom during the entirety of testimony. And frequently, prosecutors will then call the officer in charge at the end of all of the testimony that they have had put in.
Thank you. Good point. Did you think there was anything wrong with the way Judge Morrow handled his comments to Ashley Chavone?
No.
Did he do it courteously?
Yes.
After the first day, did you have a conversation with Ashley Chavone?
Yes.
Can you tell us about the conversation?
If I remember the conversation, it was about the nature of the case and how it was going. I think that's the extent of it. other than that, I don't really remember anything else other than that. There was nothing, unusual about the conversation. I frequently will have conversations with prosecutors at the end of the day. Sometimes it's a matter of getting a feel for what they're thinking, because you can sometimes tell whether a prosecutor is sweating their case.
Did you have a conversation with her at the end of the second day of testimony?
Yes.
Can you tell us about that conversation?
It's much the same.
Did you have a conversation in which you told her what people referred to her as, what her nickname was?
Yeah. Yeah, because sometimes she would get really hot in terms of her questioning style. And at the end of the second day, I think we were pretty close to finished with the case. And I said, you need to kind of back it off a little bit, because, there are people in the building who refer to you, in particular, a number of defense counsel, as little nasty.
If you had one word to describe her personality, what would it be?
Objection, relevant.
What is the objection?
Relevance.
Judge, this witness, I'm sorry, strike that. Ashley Chavone has testified pursuant to questions by Ms. Weingarten that she was not super sensitive. This answer that this witness will give will indicate that she was super sensitive. She was prickly.
Any further objection?
No, I still think it's not relevant.
The objection is overruled. Continue.
Would you please tell us what that one word would be?
I found her to be prickly.
What do you mean by prickly?
She's somebody that might take herself a little too seriously and get upset over things that you probably ought not to be upset at. I mean, look, I've been doing this for almost 40 years. I've tried close to 300 cases in my life, and I've tried them all over the country. And there are just some people who they can take offense to things that they shouldn't take offense to.
Directing your attention now to the third day of trial, did you give closing arguments on that day?
Yes.
After the closing arguments, did you make a directed verdict motion?
Yes.
After that directed verdict motion, did Ashley Chavone then ask to be allowed to put in 404B evidence?
She most certainly did.
Did that seem unusual to you?
Well, it would have, I thought it was unusual because, in essence, to put in the 404B evidence, she would have had to reopen her case, which would have meant that the entirety of the case would have had to be reopened and the entire case would have had to be retried.
So Judge Morrow denied the motion, is that correct?
That's correct.
Did you think there was anything improper in his denial of the motion?
No.
Did you think that he was discourteous to Ashley Chavone when he denied the motion?
No.
Did he act disrespectfully to Ashley Chavone?
No.
And let me also include Anna Bickerstaff. Did you see any interaction between the judge and Anna Bickerstaff?
That was disrespectful?
Well, let's start out with, did you see any interaction between the two of them?
No.
At any time during the trial, did you think that he was disrespectful in the way he addressed Anna Bickerstaff?
No.
Was he ever discourteous to her?
No.
Do you think that he treated you better than the prosecutors because you were a defense attorney?
Most definitely not.
Do you think that he did he treat you better And we haven't established that he treated you better. Did he treat you better because you're a man and they were women?
No.
Have you ever seen Judge Morrow treat men and women differently that are counsel in front of him?
No.
Did there come a time that you were directed to go into the chambers with the judge?
Well, I don't think we were directed. I do remember the judge asking us if we'd come to his chambers.
Did you think that you could say no?
Of course.
Okay. You weren't forced to go back there.
No, actually, given the fact that we're getting close to wrapping up the trial, I was interested in hearing what the judge had to say.
Were you interested in hearing what the judge had to say in terms of your performance?
I was interested in hearing what he might have to say about what he thought, how the case went in, what he thought about, the jury and whether the jury was going to be able to return a verdict or not. And of course, I'm always interested in how I perform because my clients' lives are at stake based on how I perform.
Did Judge Morrow offer a criticism of your cross-examination of the DNA expert?
He most certainly did.
Can you tell us what that was?
Yeah, basically, he pointed out something that from my perspective, I was probably too close to it, and I was responding to what the prosecutors were doing as opposed to looking at it from the perspective of if this man had strangled this woman, as the prosecution was saying, then what would have happened is he would have left, there would have been epithelials on her neck, and there would have been DNA evidence on her neck. Now, of course, given that this case arose in part as the result of a rape kit that had been rediscovered, the rape kit did not go to the matter of DNA on the neck. It only went to DNA in the vagina, in her anus, and in her mouth. And so he said, instead of playing on their field, I could have simply pointed out that there was no DNA evidence indicating that he strangled her.
And was strangulation the manner of death?
Yes.
Did you think that you might use this if you had to retry this case?
Oh, heck yes.
Was this a tip from the judge?
I don't know that it was a tip. I just think it was one of those things that, he pointed out, and I thought it was clear that, that I should have thought of that.
You didn't resent him for saying this?
No.
He didn't treat you you didn't feel that you were being treated with disrespect or discourteously?
No. Trust me, I've been treated with disrespect and discourteously in courtrooms in Mississippi, Alabama, and Georgia, and bad acts, believe it or not. But this was not one of those situations.
Just for the record, is bad acts in Michigan?
It is indeed.
It's not in the South.
No.
Thank you. Did you go during this? We've already gotten into the conference and back. I apologize. You went back with Ashley Chavone and Anna Bickerstaff and the judge. Is that correct? Back to chambers?
That's correct.
Do you recall whether the door was open or closed?
The door was open.
How long do you recall this chambers conference lasted?
Maybe 15 minutes.
Do you recall, besides the DNA evidence, do you recall what else was discussed?
Well, one of the things that the judge in particular discussed was Mr. Matthews on the stand testified that because of some burns on his leg, he could not have sex in a certain position. And also he indicated that Marcella Robinson was pregnant with his child. And so rather than having sex in a conventional missionary position, he had it in from the rear. And I think basically the judge was pointing out something about how Mr. Matthews how his testimony went in And basically, that was it.
Did you hear Ashley Chavone answer any of the judge's observations?
She responded.
Did she respond forcefully, or let me stop there. Did she respond forcefully to his argument?
Yes.
Or his observation? She didn't seem cowed to you? You know what I mean by cowed?
Yes, I know what you mean by the word cowed. And no, she did not demonstrate anything that indicated that she was cowed in that conversation.
She's a fighter, isn't she?
Yes, she is.
That's part of her reputation, correct?
Yes, it is.
Judge, I object to the leading nature of these questions.
Objection to leading questions is sustained. Do you want to make a separate record, Ms. Jacobs?
I can ask it a different way if I may, Judge.
Great, thank you.
If you could pick one word to describe Ashley Chavone's demeanor during this conference, can you tell us what it would be?
I would say that it was professional, but somewhat argumentative.
Who was being argumentative?
Ashley.
After you left this, strike that. Mr. Noakes, if you found yourself in a chambers conference going for 2 hours and you wanted to leave, how would you go about leaving the judge's chambers?
I would politely excuse myself, saying, in effect, Your Honor, I have some other things to do, and I'm going to take my leave if you don't mind.
Thank you. What was Anna Bickerstaff doing during the conversation between the judge and you and Ashley and the judge? I'm sorry, Ms. Chavone.
As best I remember, Ms. Jacobs, she was there, she was present, and I don't remember her saying much of anything.
After the chambers conference, where did you go?
We were still waiting for the jury, and so I went to the lawyer's lounge.
So on this was now the third day of trial, is that right?
Yes.
Did you feel that the judge acted improperly at any time during this day?
No.
Did you feel that he acted discourteously to anybody?
No.
Did you feel that he held anybody up to strike that? Did you feel that he was not respectful to anybody?
No.
Okay, and let me just say that I should say, did you feel that he was disrespectful to either Anna Chavone, Ashley Chavone, Anna Bickerstaff, or you?
No.
During this conversation in chambers, did you feel trapped there?
No.
If I can just take one moment, Judge,
Yes.
just a minute.
Certainly.
Okay. After the conversation in chambers, do you remember the judge talking to the two prosecutors in the well of the courtroom?
I remember him having a conversation with them, but I don't remember what the nature of the conversation was.
During that and this is in the well of the courtroom, correct?
Yes.
Did you notice anything about the demeanor of Ashley Chavone Ashley Chavone during this conversation? Her demeanor changed?
Not that I recall.
during this conversation with the judge, did Anna Bickerstaff's demeanor change?
No.
Was there, in the Chambers conference, was there any bad language being used?
Not that I remember.
1 minute, Judge. If you had heard, because you are a minister, would you have been upset if you heard foul language in the Chambers conference?
Yes, I would have been upset. I mean, part of it is not only am I a minister, but I consider myself a gentleman. And, you know, while rough language may be appropriate in certain settings, I certainly don't think it's appropriate in a courtroom or in a judge's chambers.
To that point, did you ever hear Judge Morrow use sexually graphic language inappropriately?
No.
Do you remember Judge Morrow making fun of your client?
I don't know that I would call it making fun of my client, but I do remember basically saying that he thought Mr. Matthews was exaggerating when speaking of his sexual prowess.
Thank you. Turning now to the fourth day of trial, tell us the result of the verdict. Tell us what the verdict was.
It was a hung jury.
After the jury announced that they were hung, I think this might have occurred before the jury came out. Did Ashley Chavone want to make a record about the fact that she wanted the jurors to continue to deliberate?
Yes.
Did she say she wanted an Allen charge?
Yes.
Did she also demand that notes, the jury notes, be read into the record?
Yes.
So in no sense can you say that her demeanor was anything other than feisty. Would that be a good word to describe what she was acting, how she was acting?
I think that's a fair description.
After the judge declared a hung jury, did he then want to set an immediate trial date?
Yes.
Was Anna Chavone amenable to that?
You mean Ashley? Yes, she was.
She didn't say, no, Judge.
No.
Wait till next week. She was willing
she
and eager
didn't.
to set another date, correct?
That's correct.
Got enough paper over there? Did their demeanor change after the jury hung?
I don't think so. I mean, look, I've lost cases in my career. Not many, thank goodness. But yeah, my demeanor typically changes a bit, but it wasn't, if her demeanor changed, it wasn't noticeable other than, hey, we didn't get the verdict that we hoped for.
Did there come a time that you found out that a motion to disqualify had been granted in your case, a motion to disqualify Judge Morrow?
Yes.
How did you find out about this?
When Mr. Morrow's case was suddenly on the docket of visiting Judge Hathaway.
Do you mean Mr. Matthews' case?
Mr. Matthews' case, I'm sorry. Yes.
And how did you find out it was on Judge Hathaway's case, on Judge Hathaway's docket?
I looked at I looked it up on Odyssey because I was trying to determine why we weren't on a particular date. And then I went in and talked to Mark Ulatowski, who was Judge Morrow's clerk. And I said, well, I thought we were going to have a trial here. And he indicated to me that
objection to the hearsay.
It's not for the truth of the matter. It's how this witness responded to it.
Anything further, Ms. Weingarten?
think it is for the truth of the matter.
What?
Otherwise, it's irrelevant, what Mr. Ulatowski said.
Ask your question again and don't answer yet, Mr. Noakes.
I'm sorry, Ms. Jorgensen, could you read my last question over?
Yes, just a moment.
Thank you.
And how did you find out it was on Judge Hathaway's case, on Judge Hathaway's docket?
And the answer is that he found out through Mark Ulatowski, the judge's.
No, my
That was
answer is I learned
Don't
through
answer.
Odyssey.
Don't answer it yet. So you were asking, you said not for the truth of the matter asserted, but to find out, what was it you were trying to find out then?
What happened, where his case was.
All right, I'm going to ask you to rephrase your question then so that it does not sound as if it is hearsay, because I'm not following the purpose that it was going to be received for.
Mr. Noakes, were you surprised that your case had been transferred?
Yes,
Incidentally, is Judge Hathaway a retired judge?
yes,
Is he, as a retired judge, he is not Judge Morrow's alternate, is he?
no,
Were you ever served with a copy of a motion to disqualify?
no,
Were you ever notified of the date when it would be heard?
no,
Were you ever present at a hearing just by accident when they were arguing the motion?
no,
Do you even know if there was an argument on the motion?
no.
Why did you think the prosecution made this motion?
Objection, speculation.
Any response, Ms. Jacobs?
I think it's to describe his response to what had happened. Here he had no idea that it was his case, it was in front of Judge Morrow, and all of a sudden it's been removed from a judge that was a fairly pleasant place to try a trial.
To the objection of speculation, I'm going to sustain the objection.
Incidentally, after the jury came back hung, did the judge ever grant the directed verdict motion?
No,
Have you, since you found out that the case had been transferred, did you ever get to see a copy of the motion to disqualify?
I only recently saw a copy of the motion, and that was provided to me by you, Ms. Jacobs.
Is there anything in that motion that indicated that it was ex parte?
It would appear that it was. In fact, it appears that it was sealed so that I couldn't see it.
Did the motion itself say ex parte?
Yes.
Could you be wrong on that?
I might be, but the fact of the matter is I wasn't asked to be there and I wasn't there. And apparently the motion was granted without me knowing about it and most certainly without my client knowing about it.
When you read the transcript, did you think there was anything missing from it? And this is the trial transcript.
No.
This is my last question, Mr. Noakes. Could you describe Judge Morrow's voice for us?
He has a fairly booming voice. I mean, he's a large man. I mean, I'm 6'1", 200 pounds. He's probably about 6'3" or 6'4", maybe more. And he has a booming baritone voice.
Was there an example in which he had to project his voice because a microphone was not working? Can you tell us about that? Tell us about that.
Well, basically, at a point, the microphone wasn't working, and so he.
Where were you? Where were you?
I was at counsel table.
Okay, continue.
Rarely, whenever I'm in a judge's courtroom, if I've got a case that I'm trying, I'm usually at counsel's table. Very rarely do I stray from there. But I do remember at some point the microphone wasn't working and the judge projected. And he'd frequently do that, particularly when he was addressing members of a jury or a panel or impaneling a jury during voir dire.
Do you attend CDAM Friday afternoon lectures?
Occasionally.
Did you ever observe Judge Morrow there?
Oh, absolutely. There was a session, and he was talking about implicit or inherent bias, and that was at the Wayne County or the city county building in the auditorium, which probably seats about 500-600 people. And he was in the well, and his microphone failed to function. And so he said, they were fiddling with it. And he said, well, don't worry, I can project. And he most certainly could. And he did.
Thank you, Mr. Noakes. I have no further questions of this witness.
You're welcome.
Thank you. Any questions on cross-examination?
Yes. Good afternoon, Mr. Noakes.
Good afternoon, ma'am.
What did you do to prepare for your testimony at this hearing?
I reread the trial transcript, and I believe there were a couple of statements that I also took a look at.
What kind of statements?
Statements that I made to, I believe I made a statement to you, and I know I made a statement to some investigator with the prosecutor's office.
Okay, let's start with the statement to me. Were you given a memorandum that I wrote to Mr. Donald Campbell dated October 1st of 2020 involving my interview with you?
Yes.
Who provided that to you?
It was provided to me by Mr. Morrow's counsel, Liz Jacobs.
Did you and I have an interview in the Judicial Tenure Commission office on January 27th of 2019?
No.
You didn't come to the Judicial Tenure Commission office and have an interview in the conference room?
I did, but it was in 2020.
I'm sorry, you're correct. Thank you for correcting me. Okay, and was it just the two of us present at that interview?
Yes.
No court reporter, right?
That's correct.
And no eyewitnesses besides the two of us, right?
That's correct.
Is everything that you told me the truth?
Yes.
Now, you told me you reviewed the trial transcript. How recently did you do that?
Over the past weekend.
Is it true that throughout the hearing, the whole trial, you did not make many evidentiary objections?
That's correct.
Is it true that Judge Morrow on his own interrupted the proceedings and prohibited Ms. Chiffone from making statements and questions that she did?
On occasion, that's correct.
Would it be fair to say it was more than just on occasion? It was frequent?
No, I can't say it was frequent. I think it was on occasion. And frankly, one of the things that because
so there's no question on the table for you. You've answered the question. Thank you.
Well, Judge, I think he was answering the question and the prosecutor doesn't want to hear the full answer.
That is an objection, Ms. Jacobs. Is there an objection?
That's an objection, and I didn't mean to say prosecutor.
What is the objection?
That the disciplinary counsel is not letting the witness finish his statement.
All right, the objection is overruled. Continue, please.
Mr. Noakes, in the People versus Matthews case, was the victim, who's now deceased, pregnant?
I don't recall. I don't think she was.
Did your client allege when he testified that she was pregnant?
Yes.
Now, were you present when Judge Morrow said something to Ms. Bickerstaff about the fact that she used the word "and" multiple times before questions that she asked?
Yes.
What do you recall about what Judge Morrow said to her about that?
Basically, it was as if it sounded like he was saying you're using a filler word. And by doing that, you tend to make things compound as opposed to a simple, direct question.
Did he say that from the bench?
I think he might have said it while he was on the railing at one point.
Right. Did Ms. Bickerstaff ask for feedback, or did he just give it on his own?
I believe he gave it on his own.
Did she seem to appreciate the feedback?
That I couldn't tell you.
Did there come a time after Dr. Galita testified that you all took a 5-minute break?
Yes. Can I take a break? I've got a client in custody who's calling me right now. And I'm going to need like 2 minutes to deal with that.
I have no objection, Judge.
Thank you. No objection.
We will take a, do you think you need more than 5 minutes, sir?
5 minutes should be sufficient so I can reschedule our call because I thought I was going to be on this morning.
All right, let's try to be back then in 5 minutes, just after 4:30.
All right. Thank you.
Thank you.
Thank you, counsel. I'm back.
Thank you. Ms. Weingarten, are you ready to continue? You are muted.
forgotten where I left off. Could we have the court reporter read it back?
See if Ms.
I'm sorry, I was muted. I apologize. The last question was, I'm sorry? The last question was, did there come a time after Dr. Galita that you all took a 5-minute break? And the answer was yes. Can I take a break?
Right. Mr. Noakes, you told us you reviewed the transcript recently. I'm referring to June 11th, page 177. Do you have the transcript in front of you?
No.
No. Okay, so I'm going to read to you something and you tell me if this sounds like something you said. The court, Ms. Chiffone rested. The court said, all right, so far the guess is good. What is your pleasure, sir? And he's referring to you. And you said, Your Honor, may I have 5 minutes, please, to consult with my client? Does that sound like something you said?
Yes.
And were you wanting to consult with your client to see whether or not he wanted to testify at trial?
Yes.
You told us earlier your client was incarcerated in the back. Is that right? The back of the court?
Well, at that point, he was sitting in the courtroom in front of me.
Okay. Did he stay in the courtroom during that 5-minute break, or was he brought by the deputies back to the locker?
No, he was in the courtroom.
All right. And did you discuss with him whether or not he wanted to testify?
Yes.
During your discussion with him, did you see what Judge Morrow was doing?
I don't know if I did or didn't, because at that point I was focused on my client and whether I was going to put him on the stand or not.
Did you hear Judge Morrow say to Ms. Bickerstaff from the bench words to the effect of, I'm going to come down there and talk to you, but because what I have to say could make you blush?
No.
Did you see Judge Morrow sit at the prosecutor's table next to Ms. Bickerstaff?
No, not that I remember.
And were you able to hear anything that took place at the prosecutor's table during that 5-minute break?
No, I was focused on Mr. Matthews.
All right. After the break, did you continue to resume taking testimony?
Yes.
And is that when Mr. Matthews testified?
Yes.
Now, I know you don't have the transcript handy, but if I refer your lawyers to page 178 on the June 11th transcript, it shows that there was a 5-minute break between 2:52 p.m. and 2:57. Does that seem about right, that you had those 5 minutes to talk to your client about whether he wanted to testify or not?
It seems right.
All right. Now, the next day, June 12th, did you make a motion for directed verdict?
Yes.
And did Judge Morrow rule on that motion?
No.
What did he say? What was his ruling when he did not rule?
Well, he held it in abeyance because at that point, I believe the jury appeared to be hung. And so that's where we were.
All right, so I'm not sure if you're confusing your dates. We're talking now about June 12th. Right when the prosecution rested, you presented your defense, and then you made a motion for directed verdict.
Well, I think now I may be remembering this incorrectly, but normally I would make a motion for directed verdict at the end of the prosecution's case before I put my client on.
Okay, so in whichever order it happened, the relevant thing is Judge Morrow held his ruling in abeyance. Is that true?
That's correct.
And did he ever rule on the motion for directed verdict?
No.
When you were in chambers, was there a discussion about the fact that Ms. Chiffone used the wrong standard when arguing against the motion for directed verdict?
I don't remember if that was part of the discussion. It may have been.
Do you recall Judge Morrow handing you and Ms. Chiffone a law book with the standard for directed verdict?
Yes, I do.
Did that occur in chambers?
Yes.
What was the purpose for which he gave you those books?
Well, it makes me remember that it was for the purpose of understanding what the appropriate standard was for a directed verdict motion and what the proper standard was for arguing against a directed verdict motion. I took it as legal education.
Okay. Do you recall what court rule he cited you both to?
No,
Do you recall the content of the court rule that he cited you to?
no,
Do you recall whether the court rule he cited you to said that a judge can grant a motion for directed verdict even after the jury returns a verdict?
I don't remember if he said that, but if that's what the rule says, then I'm certain that's what he said because he was quoting from the rule.
Did you ever hear Judge Morrow say in public in front of Miss Chiffone to Miss Bickerstaff that she should find a different mentor or teacher because Miss Chiffone wasn't really very good?
God, I don't remember that at all.
One moment, please. In the in-chambers discussion, you told us that Judge Morrow said that the defendant's testimony about his sexual prowess was an exaggeration. Is that fair to say?
That's fair.
Can you remember what Judge Morrow's exact words were involving that topic?
No. I mean, let me just put it to you this way. Since June 2019, I've tried 9 more cases. I don't remember what happened beyond what I've told you today.
All right, so if you don't know the answer to a question I'm asking, just say so, and that's fine, we'll move on. So my question was, do you remember Judge Morrow's words or the sentiment of his words?
No.
Did he refer to the defendant's penis as a dick?
I don't think so.
Did he refer to the kind of sex the defendant described when he testified as doggy style?
He may have.
Did he argue with Ms. Bickerstaff about what the DNA evidence showed and finally said it only shows that they fucked?
Well, I remember him saying basically it only showed that they had intercourse because that's what my client testified to. He said he had intercourse with her because that was his girlfriend. And so on the stand, he admitted that he had sexual intercourse with her.
My question was, did Judge Morrow refer to that as fucked?
Not that I recall. I would have taken offense to that.
Did he critique Ashley Chiffon's voir dire in the in-chambers discussion?
He critiqued her voir dire and he critiqued my voir dire.
Did he give, you've answered the question.
If you'd allow me to complete the answer. Judge Morrow is one of those judges who finds most lawyers do an inadequate job of voir dire because they really don't get at whether a juror is going to be fair and hear a case and base their rulings or base their decision on evidence. That's why he talks about such things as inherent bias. And so,
okay,
yeah,
sir,
he critiqued
sir,
it.
Judge, I object. His answer is not responsive to my question.
I think it was responsive, Judge. Can we have the question read back?
One moment. So the question, we'll hear that and then ask for the answer. And I know, Mr. Noakes, you may have additional information, but she has a right on cross-examination to ask your question and ask just for the answer. So let's hear the question.
I understand, Your Honor.
I know you do. Let's hear the question, please.
One moment, Your Honor.
Certainly.
Did he critique Ashley Chiffon's voir dire in the in-chambers discussion?
All right, so that is the question. Ms. Weingarten, is that the question that you meant to ask?
Yes.
All right, and now for your answer, Mr. Noakes, please.
Yes.
All right, let's continue.
Mr. Noakes, back in June of 2019, may I ask how old you were?
63.
And may I ask
No,
how
I
many
take that back. I was actually 62. I didn't turn 63 until September.
Okay. And may I ask how many years you had been practicing law at that point?
I first became licensed in 1983, so since 1983.
I'll do the math later. Okay. When you said Ms. Chiffone didn't seem cowed, first of all, how do you spell that word?
COWED.
And what does that word mean to you?
Means somebody who feels intimidated or is reluctant to speak up because they feel as if the other person has an inordinate amount of power over them.
Now, after the in-chambers discussion, you testified that you went to the lawyer's lounge. Is that correct?
Yes.
Were you present when the judge excused the jury for the day?
Yes.
So for how long were you at the lawyer's lounge?
I don't remember.
Do you recall returning to the courtroom after you went to the lawyer's lounge?
Yes, because yes.
And do you recall seeing Judge Morrow having a conversation with Ms. Bickerstaff and with Ms. Chiffone?
No.
What do you recall seeing Judge Morrow do when you returned from the lawyer's lounge?
As best I remember, he was getting ready to go back on the bench because he was going to call the jury back in.
And did he bring the jury back in?
Yes, he did.
Did he tell them he was releasing them for the day?
Yes, he did.
Did he in fact release them for the day?
Yes, he did.
So during any of that, did you see Judge Morrow have a conversation with Ms. Bickerstaff and Ms. Chiffone near the prosecutor's table?
I really don't remember that.
Okay. Did you ever hear Judge Morrow talk to them about their height, weight, or body muscle mass?
No.
Now, eventually you say that the case got transferred to Judge Michael Hathaway, who was a retired visiting judge. Is that right?
Yes.
And you learned of that because Judge Morrow's clerk told you to go to a different. No? How did you learn of it?
I learned about it by looking at Odyssey and finding that my case had been moved. Now, I confirmed that in a conversation with Mr. Ulatowski.
All right. Do you know who removed it from Judge Morrow's docket to Judge Michael Hathaway's docket?
Yes.
Who did?
Judge Kinney.
Who is Judge Kenny?
Judge Kinney is the chief judge for the Third Circuit Court.
So he's over the criminal division, the civil division, the family division, the business court, all the courts. Is that fair to say?
That's correct.
Have you seen the order signed by Judge Kenny transferring the case to Judge Michael Hathaway?
No.
Now, you're not blaming Ashley Chiffone or Anna Bickerstaff for directing that the case be transferred, are you?
I'm not blaming anybody in this.
All right. Do you know whether a motion for disqualification was ever argued?
No.
Excuse me, you said no. Does that mean that you don't know, or you are saying no, that it was never argued?
I don't know if it was ever argued.
Okay. Did you appear before Judge Michael Hathaway when the case got transferred to him?
Yes.
How many different times have you appeared before him or in chambers with him to discuss this case?
Probably 5 or 6.
And were the prosecutors, Ms. Chiffone and Ms. Bickerstaff, present also?
At all but one conversation.
Was there a different prosecutor who stood in on that other conversation?
No,
I assume you are not admitting you had an ex parte conversation with Judge Hathaway. Is that
no,
true?
I'm telling you, I did have an ex parte conversation with the judge. It was not about the case. It was about my physical condition, because at that point I had an unspecified illness that I needed to let the judge know that I had.
Okay. When you've attended Judge Michael Hathaway's courtroom 5 or 6 times with the prosecutors present, was there discussion about whether or not they could refile a 404B notice in front of Michael Hathaway?
Yes.
And whose idea was it for a new 404B notice to be filed?
As far as I know, it was the prosecutors, both Ashley Chiffone and Hannah Bickerstaff.
Was there a discussion about whether the law allows them to refile that motion or notice in front of another judge?
Yes, there was.
And did they cite law that allowed them to refile in front of a new judge?
Yes, they did.
Did you concede on the record that it is appropriate for them to have the right to file in front of a new judge?
No, I did not.
Have you seen a transcript that has been marked? In your trial preparation, have you seen a transcript that's been marked Exhibit 14?
In my trial preparation?
Yeah, in your
Objection.
preparation for your testimony today, did
You've brought
anyone
me-
show you a transcript dated September 23rd, 2019 before Judge Michael Hathaway?
I don't know if I saw that or not.
All right, I want to read to you a portion of that transcript.
Can you tell us what exhibit number it is, please?
Yes.
Is that Exhibit 14?
Yes.
Thank you.
One moment, please. I need to get to the page. Okay, have a moment, Your Honor.
Yes.
She hasn't told us what page yet.
I'm sorry, Your Honor. I should have had this marked. Could I have a few minutes to go through this?
Yes. It is almost 5. Let's come back at 5 o'clock. Does that give you enough time?
Yes.
All right, we'll be on break until 5 o'clock. Mr. Noakes, you are still under oath under the sequestration order. And we can turn off our microphones and videos at this time for 10 minutes.
We're on.
So we just need to get Mr. Noakes back in. Mr. Noakes, if you can hear us, there you are.
I can hear you. I'm here.
All right, thank you. We're ready to proceed, Ms. Weingarten.
Yes, I'm sorry for the delay.
That's all right. Ms. Jacobs, are we ready to proceed?
Yes, ma'am.
All right, go ahead.
Okay, Mr. Noakes, at the hearing held before Judge Michael Hathaway on September 23rd, 2019, was there a discussion about whether the prosecution could renew or rewrite or re-argue its 404B notice?
I believe there was.
And was the conclusion by Judge Michael Hathaway that yes, they could refile it in front of him?
Yes.
And did you concede that he is right?
I don't remember conceding because I plan to appeal his decision to the Court of Appeals because I believe the state of the law was that once a judge at the circuit court level had ruled on the issue, that it was the law of the case.
All right, I'm referring to page 4 toward the bottom. I'm going to read to you a small colloquy between you and Judge Hathaway. The court said to you, well, you are arguing the substance of the offer now. Preliminarily, I just want to clear the air on whether I have authority to even rule on the motion. And Mr. Noakes says, Your Honor, you have authority to rule on the motion. And the court says, yeah. Do you recall that?
Yes, I do. And he did have the authority to rule on the motion.
Did you ever appeal that decision?
No.
Now, I want to read you some statements and some answers that Judge Morrow gave, some questions and some answers, and ask you
Now,
whether you recall.
If
Judge
I
Morrow.
may, counsel, I need to complete the answer that I just gave you.
Okay, go ahead.
There was an additional comment from Judge Hathaway, which I don't know if it was on the record or not, which is, well, they're going to have to figure out how they're going to prove that 404B evidence. I don't know how they're going to get it in.
All right, but that has nothing to do with your conceding that Judge Hathaway had the authority to rule on another 404B notice, right?
Yes.
So I want to ask you, I'm going to read to you some questions and answers and ask you if you heard Judge Morrow say any of these things in the in-chambers discussion, okay? Judge Morrow was asked, did you say words to the effect of, quote, all you did was show they fucked? And Judge Morrow answered, Judge Morrow does not recall saying the words quoted above, but he probably made a similar statement. He certainly does not recall that he emphasized the word fuck and did not believe he did so. And then he's asked, did you use that specific word, fucked, while you were discussing the issue with her? And Judge Morrow wrote, Judge Morrow believes that he probably did use that word. He did so referring to the act of copulation and in a manner that was not unbefitting of the circumstances. Did Judge Morrow use the word fucked in the in-chambers discussion?
As I've testified today and as I previously testified, I don't believe he used that word.
Okay. I'm going to ask you then at trial, I want to ask you this question. At the trial, had the defendant testified that he and the deceased victim engaged in, quote, non-traditional sex? Do you recall the defendant testifying to that at trial?
Yes.
Do you recall in chambers Judge Morrow confronting APA Chiffone about her personal bias and inexperience with what non-traditional sex was?
I remember the judge commenting on inherent bias, basically making the point that we all have biases that we often are not aware of. And he pointed that out to Ms. Chiffon.
And when he did that, did he talk about her personal bias and inexperience about what non-traditional sex was?
I believe he commented on what she may or may not know, and I don't know if it was specifically about sex, but he certainly did talk about inherent bias that she may have.
Did he tell Ms. Chiffon that most people do not interpret non-traditional sex the way she does?
Yes, I remember that.
What did he say about that?
Well, I think that's the sum and substance, what you just put in the question.
And you can't remember more information that Judge Morrow said about that topic?
No.
Okay. While in chambers, did Judge Morrow laugh at the defendant's testimony that he did not have traditional sex with the victim because she was pregnant and he did not want to hurt the baby?
Yeah, I think he may have laughed at that. And that gets to the point of Mr. Matthews exaggerating.
Did Judge Morrow say words to the effect of, how big does this guy think he is, referring to his penis? Do you recall that?
I think he did.
Do you recall Judge Morrow saying, does he think his dick is so big that he would hurt the baby?
I don't recall that part, but I do recall basically the conversation that this guy is exaggerating.
Do you recall Judge Morrow saying, this guy must feel real good about himself to think his dick is that big?
I don't remember him using the word dick. And I think the conversation was, how big does he think he is? And I think that was the extent of it.
And the reason he even mentioned that was because he was making fun of the defendant's testimony. Is that true?
Well, he was saying that the defendant exaggerated.
And he was saying it because it was funny to him, and he said it in a joking manner, right?
Objection, he can't justify what is funny to another person.
Any response?
I can rephrase the question.
All right.
Did he say it in a joking manner, or did he say it in a serious manner?
I don't recall the manner in which he said it at this point.
Now, you said in chambers, Judge Morrow criticized both your and Ms. Chiffon's voir dire. Is that correct?
Yes.
Did Judge Morrow?
And let me just put it this way. I would use the word critique rather than criticize. Criticize tends to be something a little more, it means something more than critiquing. He critiqued.
We'll go with critiqued, okay? So in doing so, did he propose to Ms. Chiffon a question he would have asked if he had been the prosecutor on this case?
That I don't remember.
I'm going to read to you the question and ask you if this is what Judge Morrow said. Did you say words to the effect of, quote, if I want to have sex with a woman on the first date, how would I figure that out? I wouldn't ask if she wants a family or children or what she does. I would ask her, have you had sex on a first date before? Would you sleep with me on a first date? Do you recall Judge Morrow giving Ms. Chiffon that voir dire question?
Yes, I do.
One moment, please. You indicated that you were interviewed by Detective Bivens from the Wayne County Prosecutor's Office?
I don't know if it was Detective Bivens. I just know it was a detective from the Wayne County Prosecutor's Office.
And do you know if that interview was done in person or by phone or some other?
It was done in person in his office.
Was it recorded by video or audio?
I don't believe so.
Was it done in question and answer form on paper?
What do you mean by on paper?
Well, did you have to read a statement and sign it, purporting it to be your statement?
No.
Have you ever seen what the interviewer wrote down about what you said happened?
I saw a statement in the last few days from that detective.
Okay, and who showed you that statement?
It was given to me by by Judge Morrow's counsel.
Was it a 9-page typed statement to Kim Worthy, our elected prosecutor?
Oh, not that I recall.
How long was the statement you were given to read?
I don't remember, but let me just tell you this. I only spent
There's really no question on the table. You've answered the question. You don't remember. Were you given a 9-page report that was typed to review before your trial preparation for today?
And who was the author of that report?
James Bibbins, a detective for the Wayne County Prosecutor's Office.
I don't recall it being that lengthy.
Was it a summary of what everyone they interviewed talked about?
No, I received a summary of what I talked about.
All right. And do you have that summary with you here today?
No,
How long was the summary that you received?
I don't believe it was more than a page.
In fact, it was really only 2 short paragraphs, right?
That would be about right.
All right, thank you. I have no other questions.
Ms. Jacobs.
Thank you. Mr. Noakes, did there come a time after this trial that you found out that someone in the prosecutor's office wanted to talk to you?
Yes.
Can you tell us about that?
Yes, I received a telephone call from Athena Syringas. No, I take that back. It wasn't a telephone call. There was a hearing, I believe, in front of Judge Hathaway, and Athena Syringas stood in for APA's Chiffone and Bickerstaff, and she indicated that they had wanted to speak to me, and it was after that that I met with the prosecutor's detective.
Did you get the impression that they had not been trying to reach you at all?
Yes. I have a phone number and I have an email address, and I was in Frank Murphy Hall of Justice almost every day.
Do you remember talking to someone named Bivens in the prosecutor's office? Was that the name of the man?
I can't attest to the person's name, but I talked to somebody who purported to be the chief investigator for the Wayne County prosecutor.
Do you remember that statement that he took was only 3 sentences long?
I don't remember how long it was, but I will say this: we didn't meet for very long at all.
Did he seem interested in what you had to say?
Not particularly.
No further questions.
Nothing further.
All right, thank you. May this witness be excused?
Yes.
Yes.
Thank you, Mr. Noakes. We're going to excuse you at this time. Keep in mind you are still under the sequestration order. Thank you.
Thank you, Judge.
Right, and you may just push.
I'm gonna leave now. Thank you.
Thank you. Mr. Campbell, I think you had indicated that this was going to be your last witness for today.
That is correct, Your Honor.
Thank you. Is there anything further that you or Ms. Weingarten need to put on the record before I stop the streaming?
No,
I
Your
don't
Honor.
know that it has to go on the record, but could we hear what the next day's events are going to be?
Yes, just a moment before you start, Mr. Campbell, and I will stop this.